May I pray for Lordship's leave to mention item number 26 of the Lordship's days list. Now, there were certain directions to file an affidavit and exchange of affidavits from both the sides, which could not be done. Would it be Lordship's kind pleasure to take it after vacation? I've already informed the other side.
My lord, I am there, my lord, in item 26. My lord.
26. Post it 1 week after vacation.
You are the petitioner.
Appellant.
My lord, appellant, my lord.
Appellant.
You are the appellant. Yes, ma'am.
Writ petition respond.
So 1 week after vacation.
Great.
Yes.
Yes.
Come.
Maintaining melody item number 26 of the monthly list.
Monthly list.
Yes, melody.
What happened?
Really, I am suffering melody by the. Actually, melody panel was prepared in 2020. Assistant professor in a government aided college. The single judge allowed the appeal.
How did we update it?
Stay was refused. College Service Commission filed an SLP. SLP was dismissed. Now the application for modification application has been filed before this. Because of this pendency of this application, my lord, already 21, my lord, the selection.
Mr. Jana,
My
we
lord,
got the combined list.
I know, my lord,
How
really
can
I am
I-
suffering, my lord, because of this. 3 years already lose my service. My lord,
3 years?
the 21, 22, my lord, the panel was expired, my lord. Finally, my lord,
Remind us on Monday, let us see if any progress is.
May I have your lordship's leave to mention one extremely urgent application?
Urgent application.
File
It will appear.
No, we have filed it. I was praying if it could be listed on Monday or any day.
When is the returnable date given? The date which you mention, list matter will appear. It will automatically appear. 48 hours notice, automatic it will appear.
Very well.
That is our, you
Very well.
file it, give it, right?
Very well.
May I permit for a mention?
Yes.
My lord, the application for appropriate order in connection of the appeal is the fresh matter.
New application.
Yes. No.
Fresh file.
Application for appropriate order in connection of the appeal.
Very good. You have filed it fresh.
Yes.
Was it hard earlier?
No.
2025 matter.
25.
To give it.
My lord. Returnable date, my 12.
New appeal for inclusion in the list.
Well, up notice to the other side. I may be allowed to make some upgradation one of the matter. We are supplying, the appellant is supplying since 2007 onward. Discriminating the appellant. I am paying for upgradation.
Upgradation at this stage.
But
not
it's a
possible.
very sensitive matter, yes, supplying.
Very sensitive, but
Yes.
what can we do,
But
sir?
I have given notice to the other side.
We are
If
very happy
possible,
to
any day at any time,
Sorry, sir.
I'll be.
Yes.
This is an assigned matter. It has been assigned to your lordships. My lord, a group 5 appeal. My lord, what I was praying for, if it could be just come up on any day, my lord, there's no scope for any interim order. My lord, we could just file and circulate the paper books before the vacations, and my lord, after that, my lord, it could be taken up post it.
No, when did you file it?
No, it has been filed, my lord. It was taken up by the regular bench. My lord,
Then?
that honorable bench was pleased to release it. Now it has been assigned to your lordship's bench.
Assign when?
My lord, date of assignment is on 2nd of September, my lord.
So who is your other side?
My lord, I've informed them, my lord. Mr. Rahul Kormukar was appearing. My lord, I informed his junior today as well, my lord. I had met him. And my lord, state also have informed, my lord.
Give the number, let it appear, then you mention.
I'm grateful.
Yes.
Grateful, my lord.
One lordship, I took instruction. My lord, they wants me, my lord, to argue. We want to file this our argument. At the very outset, my lord, as far my realization is concerned, there is no deportation order, only one order, that is detention stroke deportation. And that was, my lord, placed before the Delhi High Court and over here also. I am showing my lordship, kindly see order dated 11/7/2025 passed by this honorable court at the outset. My lord, order dated 11/7/2025.
to ascertain from you, we have recorded your arguments last day. We wanted to ascertain from you that if the affidavit is filed and we keep the matter on the next occasion, will you object to that? Because we want to see the affidavit.
Lord, I have,
Subject to what?
I have extensively
Argued.
tried to argue the issue of maintainability of the present writ petitions, not only on the ground of similar petition was filed at Delhi High Court, withdrawn without leave, subsequent suppression of fact and all this. Where is the scope for if your lordships had been
No,
pleased
if
to
you-
prima facie hold on the last occasion
No,
that
we
this
have
writ
not
petitions
said
has-
anything.
No,
We have-
your prima facie, your lordship said, these writ petitions have become infructuous, take instruction, whether you will withdraw it or argue
Yes,
on
that
merit.
was your submission.
Yes.
Yes, yes.
Now, if your lordship hold that this is infructuous, what is this question of filing affidavit on the issue of deportation?
Anyway, we
That
wanted
apart,
to-
that apart, my lord, I have said I will be placing today order to rule 2 and order to rule 3 of the civil procedure code. It is absolutely barred.
So that is why we are asking you. That is why we are there. We have to consider your arguments. We have partly recorded your submission. We were just it is crossing our mind because when we directed affidavits, you were also inclined to come with an affidavit, but you argued the point of maintainability.
The
Now
first
we are
day-
asking you if we keep it after a week. In the meantime, if you can come with the affidavit, we will finally dispose of the matter.
No, my lord. If your losses hold that it is not maintainable, why shall we exchange affidavit?
All right, all right. That is what we wanted to know.
Secondly, second question is, on the first very day I appeared before your lordships, I took the question of maintainability of this writ petition.
Will it
But
kindly,
your lordships are aware if the writ petition is not maintainable,
will it kindly
all
recall that,
subsequent orders are nullity. That is settled law.
All right.
will it
Yes.
kindly recall, my lord, at the same time, they took time, my lord, 10 days for filing affidavit so far the merit is concerned. My lord, I am placing, my lord. 11/7/2025, Lordship first order.
Yes, Mr. Bosumallik, where is the Advocate General?
Not a, he is today, my lord, addressing before Supreme Court. That is why, my lord,
Yes.
11/7/2025, Lordship will find the page 2, the order passed by this honorable court. একটা কপি দিন না, আছে কপি দিন না। 11/7 অর্ডার দিতে পারবেন না? Page 2, my lord, may I please? My lord, learned advocate appearing for the petitioner submit, second paragraph, that Bengali speaking people have been illegally detained in New Delhi, Danish, a migrant laborer employed and working at Rohini, New Delhi, along with his wife, minor son, had been illegally detained beyond 24 hours without being produced before.
Yes, yes, we know that order.
Then, my lord, kindly see, skip one paragraph, third paragraph. Kindly come. This court has the power of the same page. This court has the power to issue writs, including habeas corpus under Article 226 of the Constitution of India, which allows it to address violation of fundamental rights, even if the detention occurred in another state. This was the view taken by this honorable court at the very outset in presence of them, my lord. This was never challenged. Turn to next page, my lord. Page 3. There was a specific direction
I think about one plus question.
Yes.
Then, my lord, turn to next page. There was a specific direction, specific question raised by this honorable court. So far, my lord, the Union of India, my lord, not produced any scrap of information before this, my lord, highest court of the state. Page 3, my lord, second paragraph. 6 point, my lord, question said by this honorable court. Then, my lord, this order, next order, my lord, kindly come to page page 2, court order of this honorable court. What is, my lord, the statement made by the Union of India at that point of time, my lord?
Mr. Chakraborty, it is their argument.
Lordship,
You have heard their argument.
lordship,
They are saying that please show an averment in the writ petition
Lordship.
from which it can be assumed
lordship.
that the court has jurisdiction. So there are certain averments which have to be made.
My lord, that is in the,
As to that, this order we know what we have done.
yes. Here, my lord, what I try to indicate, my lord, on that
That
particular,
affidavit they have not given as regards the queries of the court.
yes, my lord.
This is
And
one.
at the same time, on that particular date, on 16/7/2025, they categorically state, my lord, the order of deportation passed on 24th June. That is what I'm trying to, my lord, draw lordship attention. Order dated 16/7/2025, second page. My lord, after skipping some line,
Deported to Bangladesh on 26th June.
yes, and the order passed on 24th June 2025. So deportation order is as well as,
Very good. But records it says it is a detention order.
at the
24th
same time, detention till deportation. Lordship knows, my lord.
as to that, sir.
I'll show. Before that, my lord, lordship, another two, my lord, the order passed by this honorable court, my lord. Now, my lord, the very outset, my lord, they have raised the question of Delhi High Court matter. Then when this matter was withdrawn, they took the plea that migrant labor board has filed on SLP or Article 32 before the Supreme Court, as a result of which this matter cannot be taken for consideration. This was first argument, Delhi High Court. Second argument, Supreme Court. And third, my lord, they are clubbing all together.
They apprised us
Lordship,
that there is a West Bengal migrant labor
Lordship,
matter
lordship,
pending before the Supreme Court.
identical issue and all this.
Await the decision in the same.
True, my lord.
We passed an order to that.
True, my lord. On
Now
that
the
day,
Supreme Court says that no, you don't
yes,
have to
no
wait.
relation. Then, my lord, I am reading, my lord, Supreme Court order pursuant to that direction, lordship hearing this matter. Thereafter, my lord, this is Supreme Court order, 2 paragraph I am drawing lordship attention.
The order to
Order, order, Supreme Court order. Lordship, কি খুঁজে পাবেন? My lord, may I hand over
Yes, got
one
it.
copy?
Yes.
My lord, kindly see, my lord, para 7 and 8. During the course of hearing, Mr. Prashant Bhushan, learned counsel, but the petitioner has referred to the order dated so and so passed by the division bench of the Honorable High Court in connection with 50 of 2025. We are informed that the above stated petition seeking a writ of habeas corpus has been filed for the release of Sonali Bibi. However, the said writ petition was adjourned to so and so date as the pendency of the present proceeding was brought to the notice of the High Court. In this regard, we clarify that the issue raised in this writ petition pending before this court is entirely different and has no bearing on the writ petition seeking a writ of habeas corpus pending before the High Court. Consequently, we request the High Court, my lord, turn to the next page, that court to immediately take up the matter. Lordship was kind enough to take up the matter immediately. Then, my lord, liberty is granted to raise the question of ascertainment of citizenship one step ahead. But because, my lord, writ court can do that. But we have instances, precedents are there. I will show. Then, my lord, what happened after this judgment, when we draw the attention of the Honorable Court, they took time on the ground of filing their affidavit so far the merit is concerned. Lordship, kindly recollect.
Which one? This
After this order, when we draw attention of this Honorable Court, a date was immediately fixed by this Honorable Court.
Yes.
On that particular date, they come and pray for, my lord, time to file their affidavit as far as merit is concerned.
When was that order passed?
No, that order was not passed verbally, my lord. Their junior came here. And my lord, the appeal before this Honorable Court is agreeable.
No. Miss Pandey appeared.
Yes,
On that day
yes.
there was a strike.
And requested us.
So far as I remember,
Yes, my lord.
she appeared and said that it is on returnable on Wednesday.
Yes.
She said that you keep it on Monday, we will argue. Monday there was a strike. She was
My lord,
there. She said that keep it
I
on
may be wrong.
Tuesday.
I may be wrong. At the same time, they prefer the intent to file.
Don't argue something which is not on record.
At the same time, my lord,
Yes,
they
what is
requested
your
us
next point? Show us. Tell us.
to furnish certain document which is in vernacular. We have sent them also. On that particular date, my lord,
Very
it's
good.
recorded, my lord, that being the situation. Now, lordship, kindly see.
No, we have not recorded anything.
Not in record of the, my lord.
Don't be under
But it is not recorded. Now it is available from this, my lord. This, my lord, the YouTube channel, my lord, that being the situation. This is their prayer, my lord. Miss Pandey is here, my lord. Possibly, my lord, he will accept it. She will accept it. Then, my lord, I am kindly come to, my lord, the affidavit filed by the, my lord, the direction was there, my lord, to file affidavit by the Union of India. There was no direction to file affidavit FRO. FRO filed one affidavit, and police is under the MHA, Ministry of Home Affairs, that is NCT, National Capital Territory, my lord. Only one authority directed, my lord, to file affidavit. Two authority came forward and filed affidavit. I realized this question, my lord, number of advocates, so that number of advocate advance their argument. Then, my lord, I am showing, my lord, lordship, kindly come to the Lina Prasad affidavit in opposition. Affidavit in opposition, my lord, they are page 31. Lordship, got it? In a connection with WPA 50 of 2025, Lina Prasad affidavit.
Yes.
Lordship, got it. Page 31. The order passed by the Honorable Delhi High Court and the submission made by the Union of India.
Page
Lordship,
31.
Page 31. Lordship, got the order of Justice Manoj Jain and Honorable Justice Renu Bhatnagar, 30/6/2025.
Yes.
My lord, paragraph 2. Mr. Sanjay Lau, learned standing counsel for the respondent state, appears on advance notice and submits that all such 5 persons are found to be illegal migrants from Bangladesh. They were asked to produce document to show, demonstrate, and they were citizen of India. They failed to provide any such document. Resultantly, they were taken to the police station, where on examination they admitted they were citizen of Bangladesh and were born in Bangladesh and had illegally entered into India. Mr. Lau submit that they are all accordingly thereafter produced before the competent authority, Foreign National Registration Office, RK Puram, Delhi, where after due verification, my lord, verification 30 days required, order of their deportation has already been passed, and they have already been deported on Bangladesh on 26/6/2025. Then, my lord, our humble submission before this honorable court, detention and deportation order passed at the same breath. I am showing, my lord, the order passed by the FRO. Lordship, kindly come to page 60.
Page
60. 58, my lord. 58 is the legible copy, 58. Madam, skipping, my lord, the box portion, last 3 paragraph. The above mentioned person have been detected to be illegal migrant of Bangladesh. They were failed to provide any suitable reason for supportive document to justify their illegal entry, overstay in India, and produce the SHO, PSKN Kajjumarg, Rohini District, New Delhi. Then the above made foreigners will not move out the community center. This is the detention order. 3rd paragraph, non-compliance. Then, my lord, this 2nd paragraph is important. The above mentioned foreigner will not move out the community center near Lal Quarter, Bijoy Bihar phase 2, PS Bijoy Bihar, Rohini District, Delhi, until their deportation. My lord, the deportation.
where you are reading, sir?
Page 58, my lord. Page 58. The order passed by the FRO. Last 3 paragraph, my lord.
The above mentioned persons have been detected to be illegally migrants.
Yes, my lord.
Then they are failed to provide any suitable reason. Then,
my lord, and supportive
to justify their
yes,
illegal.
yes, my
Next.
lord, the illegal entry in overstay. Skipping this paragraph, next paragraph. The above mentioned foreigners will not move out the community center near Lal Quarter, Swanso, Delhi, until their deportation. So, my lord, the deportation on the same breath. Lord, say, no, my lord, that's a secret document, confidential document, which cannot be, my lord, enclosed with the affidavit, only to be handed over to the court in a sealed cover. In that particular guideline issued by the MHA, said 30 days to be given, and, my lord, the state to be considered, state to be consulted. 30 days. On the 24th, my lord, they have issued this order along with the question of deportation. Arrangement will be made immediately to be deported.
So,
issued by the MHA, which is confidential, secret, my lord, all terms have been used. Then, my lord, next paragraph, non-compliance with this order will render them liable to prosecution under Section Foreigner Act of the, my lord, so and so. Then, my lord, kindly see, this is very interesting. Then, my lord, what happened? This is 24th order. Lordship will find from a document, my lord, one document they have, my lord, stated page 66. We have got the information, special informer is there, in Bangali Bosti, Bangali people will come, will arrest them and take them to the police station and all this. And thereafter, my lord, kindly come to page 68. Page 68, date may kindly be noted. 22nd June 2024, 25, page 68. Thus, you've got it at the top, date
68.
68, my lord.
Yes.
At the top, my lord, 22nd 6, 2025. My lord, before the order of the, my lord, the FRO. What is written there? GD letter. At this time, it is recorded that the mind of SI with staff so and so, house number so with Bangladeshi citizen departing belongs to the Bijoy Bihar Bangladeshi shall submitted by self. My lord, before any, my lord, adjudication, they, my lord, decided these people are Bangladeshi. On 24th,
At this time, it is recorded that the
mind SI with staff HC Satendra, number so and so, HC Niraj, head constable Niraj, HC Praveen, number so and so, with Bangladeshi citizen departing belongings to Bijoy Bihar Bangladeshi shall submitted by self. My lord, it was adjudicated on 24th. They have the police authority, my lord, termed them Bangladeshi, and my lord wrote their note in this fashion and way, and my lord, the adjudication
is an argument on merits.
True, my lord. Then I'm
We are
coming.
on maintainable.
Then I'm coming, my lord. Then I'm coming. So, my lord, this being the
Please
situation, my lord,
restrict yourself to
yes,
the argument advice
yes,
advance.
yes, my lord. Yes, my lord. Yes, my lord.
Please show us the amendments in the writ petition. If you want to show us that, please show
Yes,
us.
yes, my lord. My lord, in paragraph 10 of our writ petition, my lord, because my lord, the problem is there, my lord. They are illiterate people. They are rickshaw puller. When they receive the information they have collected and come with in this high court, and my lord, handed over all this information. The actual information is possible from the person who are presently in Bangladesh jail. Lordship, I am drawing Lordship attention.
No, in
Page
paragraph 3, you have stated that those persons are Indian permanent residents.
Yes, my lord, Paikar, Birbhum, Murarui, police station. Lordship, kindly come to paragraph 9, page 6 of my writ petition. Then I will draw Lordship attention regarding, my lord, my affidavit in reply.
Para 9.
9. The detainees are detained. Lordship, got it?
Petitioner owns land.
Yes. This is
That
one
is-
thing, citizen of India. Then, my lord, kindly para 10. According to reliable accounts from others who are detained and later released, as reported in the press, the detainees are first held in a detention center in Delhi. They were then medically examined and moved across district. After being 6 to 20 days, they were allegedly taken to the Indo-Bangladesh border and pushed across the boundary without any legal process. This kind of expulsion from Delhi is unprecedented and alarming. While similar,
This is a statement for our jurisdiction.
No, my lord, because of, my lord, this person are living in the city of in the West Bengal. They have departed.
We understood. You have
True.
said that.
I'll show, my lord, the fraction of cause of action if arise. I'll show.
Yes. Any other paragraph?
No other paragraph, my lord. At that point of time, certain information are not available. At the time of reply, we have provided certain more information. If this honorable court permit me, I'll show, my lord. Lordship, kindly see, I intend to rely upon certain judgment to show fraction of. Then, my lord, I may be allowed to show, my lord, my reply. I'm showing. Not to cut short time. Lordship is busy, my lord, before puja. I am consuming time. I'm rather guilty feeling, my lord, for that.
Guilty feeling.
Bit, my lord.
We are so happy to learn that you are guilty feeling you are having.
Lordship, my lord, I'm consuming time, my lord. Kindly see, my lord.
Yes.
My lord, I may be allowed, my lord, to read from my reply.
We wanted to cut it short. We asked Mr. Chakraborty that file your affidavit, we'll hear it. But Mr. Chakraborty,
nothing is there, my lord, to support their order. In extreme haste.
That we are not considering. We are on territorial jurisdiction.
I'll show, my lord. I am to take support from the Supreme Court judgment, and my lord,
there has to be an amendment. Now, then you can take support.
No, my lord, kindly see. This is a
with great
technicality.
respect,
My lord, technicality cannot stand on the way. So far, substantial justice is concerned.
Reply what you have
Yes, I'm showing. Lordship, kindly come to, my lord, the reply. My lord, Lordship will. This is my lord Bodhu Sheikh, father of my lord the devotee, and Lordship, kindly come to, my lord, page 5. Page 5. My lord, maybe to
Yeah.
My lord, here, my lord, we have made this averment. My lord, we people who are living in the Piker, heavily dependent upon them, they are made servant in Delhi and they are earning money and sent us to, my lord, for our life, livelihood. Then lordship kindly come to page 7, last paragraph. After some
Page
days,
5, what did you show to
my
us?
lord, I intend to show, my lord, as an illiterate person, second line, with no understanding of legal mechanism of procedural choices, the said Karisma Khatun alias Karishma was entirely dependent on the guidance provided by those around her, including concerned local, certain non-governmental organization and advocate who engaged with her at the relevant point of time. They have preferred one application in the Delhi, my lord, at that point of time, my lord, to, my lord, free her sister. My lord, this decision was taken. She is an illiterate lady. She knows only LTI. I'll show, my lord, she knows only LTI. Then lordship kindly come to, my lord, page 7, last 2 paragraph. The subsequent to the withdrawal, the said Karishma Khatun alias Karisma was advised to file a fresh petition. Accordingly, diary number so and so was lodged before the Honorable High Court. Being illiterate, she had fixed her thumb impression on the said petition solely upon instruction on the self-same date, my lord. My lord, page 7 of the affidavit, second paragraph. Without comprehending the content, my lord, they advised him to initiate a new case and thumb impression was given. Then, my lord, after some days, Karishma Khatun alias Karishma heard a news that her sister Sunali Khatun, her husband, namely Danish Sheikh, and
Mr.
her
Chakraborty, again you are proceeding on merit.
lordship.
We are not on merit.
My lord,
We are wanting to hear your argument
yes,
as regards jurisdiction.
yes, my lord. Then, my lord, I may be allowed to, my lord, rely
Your
upon the
contention, you have shown us paragraph
Yes,
3
yes,
and
yes,
9 and
yes,
10 of the writ petition, and added to that, you have shown us paragraph 5,
yes,
which says that there was a complaint lodged
yes,
and which has been that you have annexed.
My lord, in the reply we have annexed, my lord, 2 affidavit, one filed by the Karishma.
No, state has given us an instruction to us.
No.
State has filed an instruction. Yes. Anything else, Mr. Chakraborty?
Yes, my lord. I intend to rely upon 2-3 judgment, my lord. Allow me, my lord. The
Judgment on
fraction of cause of action if arose. My lord, kindly see.
So that Goa judgment covers all the judgments, Kusum ingots, which Mr. Chakraborty cited.
1961. Taking it.
Not 61 judgment.
2023.
2023.
Yes, my lord. Considering that judgment, my lord, our humble submission, fraction of cause of action arose because they are the resident of, my lord, the West Bengal. And, my lord, the 2/5/2025 circular said respective state is required to be consulted.
Show us.
My
Show
lord,
us.
I'm sure. Circular to this, circular to this, lying with the court. My lord, lordship, kindly come to, my lord, circular. As far as circular, my lord, they have stated in their affidavit, it's a secret document. Well, they are agreeable to, my
So
lord.
you were, tell
yes,
us one thing,
yes,
you were taken up from Delhi and you were pushed back.
Pushed back.
In the writ petition, there is no, you have not been able to say or disclose that from which place they were pushed back. Whether it was Bengal, whether it was Rajasthan, whether it was Orissa, we don't know.
Indo-Bangladesh border, my lord. Indo-Bangladesh border that we have mentioned in paragraph 10.
So Indo-Bangladesh border will be covering
broad
state of West Bengal and
Assam also. Assam, Tripura also.
Assam, Tripura.
But so far the Amir Khan case is concerned, previously, my lord, he was released. Lordship, kindly, my lord, recollect.
We don't know about that. You argue on this point.
My lord, Indo-Bangladesh.
Show us from the circular what you are trying to
I'm trying to show. My lord, lordship, kindly come to the circular, page number 57. 57, lordship, got it, Roman 3?
Yes.
If the suspected Bangladesh Myanmar national claims Indian citizenship and residence of a place in any other Indian state, UT, the concerned state government, UT, would send to the Home Secretary of the state, UT, and district collector, district magistrate of the para 3, page 57 of your 25 circular. আপনার সার্কুলার আছে একটা 2/5 যে সার্কুলারটা আপনি লীলা প্রসাদের জাজমেন্টে বলেছেন, এতে বলেছেন যে খুব সিক্রেট দেয়া যাচ্ছে না, সেটা থেকে পড়ছি স্যার। এটার আপনার পেজ ইন্টারনাল পেজ হবে 1 2 3 4 5 6 7 8 9 paragraph 9 Roman 3. My lord, may I read? If the suspected Bangladesh Myanmar national claims Indian citizenship and residence of a place in any other Indian state UT, the concerned state government UT would send to the Home Secretary of the state UT and district collector of district magistrate of the district from where the suspected person claimed to hail the details including name, parentage, residential address, details of near relative, etc. The state government UT collector district magistrate concerned in turn will ensure that appropriate report is sent to the deporting state government. After proper verification within a period of 30 days, all the state UT shall issue appropriate instruction to the district collector, district magistrate, and ensuring verification of claim of such suspected person well in time. During the period of 30 days, the suspected person shall be kept in holding center to ensure physical availability at the time of deportation sent back. If no report is received within the period of 30 days, the foreigner registration officer may take necessary action to deport sent back to the suspected Bangladesh Myanmar
All right, wait.
national. Our my lord, notice of motion was given prior to my lord 24th June.
Yeah.
Page 15 of Leela Prasad affidavit. Notice of motion before Delhi High Court was given to the appropriate authority prior to 24th. In undue haste, this order was passed in spite of knowing the fact the matter is pending before the Honorable Writ Court. Page 15.
Yes.
That being the situation, page 58 said they have admitted. And the order of the High Court said they have admitted. Yes, my lord, the admission is sacrosanct nowadays, my lord. I am not disputing. I am not bringing, my lord, the Evidence Act and all these things. My lord, when I filed this writ application, it is within their knowledge. When we are claiming, my lord, we are the resident of India, resident of West Bengal, my lord, as to what prevented, my lord, the authority to communicate the appropriate government, my lord, regarding my whereabouts. This is the question I put myself.
So how does that affect your jurisdiction, Mr.
My lord,
Chakraborty?
jurisdiction, but I'm coming. Jurisdiction, my lord.
You are arguing on merits. We want your answer to the question
My lord,
put by Mr. Chakraborty.
Just now I have drawn lordship attention with regard to the circular.
Understood.
This is this point lordship understood.
You have shown us the
Yes,
Supreme
ma'am.
Court order
Yes,
where issue of citizenship
Yes,
can
ma'am.
be taken.
Yes, ma'am.
You have shown us paragraph 3, 9 and 10.
Yes, ma'am.
Please don't go on the merits.
Lords,
And you
lords,
have
once
also shown us
yes, my lord.
this paragraph.
I'm trying to confine myself. my lord.
Finish? Yes.
I'm trying to
Anything else?
confine within 10 minutes. I wanted to complete it. Lordship, now the question is, my lord, the question of jurisdiction, my lord, I intend to rely on to judgment, my lord. Lordship, kindly decide finally. Judgment gulo din. Bunch gulo din. My lord, this is, my lord, a bunch of judgment. I'm not relying everything. My lord, one or two I'll rely.
Mr. Banerjee, you handed over to us a written instruction on the earlier. Do you have a copy of that? Because we will be asking 2 or 3 questions to you. This one, check it up. Eta dao. All right. Don't take my copy. You have your own copy.
Yes, Lord.
Please come with it, because here we will putting questions to you as regards 1 or 2 points. Please get hold of this.
But can you give me the Can I go through it?
Mr. Basu, you don't have.
One copy has been given, nothing was given to us.
এই কোথায় গেল ওই যে ডিজির লোকটা এই ডিজির লোকটা ওকে ডাকো তো এদিকে আসুন না ওখানে বসে বসে ম্যাডাম
Please read the first 2 pages. Yes. Yes, which judgment you are showing?
My lord, first judgment, that is Sarguja Transport Service, my lord, 1987, 1 SCC, page 5. 1987, 1 SCC, page 5. This is relating to abandoned pleading, my lord. Page
Paragraph
9, page 5. Page 5, para 9. My lord, last 4 line I am reading, my lord. Para 9. My lord, our pagination, internal pagination.
Yes, yes.
Last 3-4 line, we however make it clear, whatever we have stated in this order may not be considered as being applicable to the writ application petition involving personal liberty of an individual in which the petitioner prays for issue of writ petition in the nature of habeas corpus. And my lord, or seeks to enforce the fundamental right guaranteed under Article 21 of the Constitution, since such a situation stands on a different footing altogether. Here, my lord, at a point of time, they have left certain, my lord.
So what
without
is your argument?
My lord, our argument is without taking leave. My lord, they have filed the second writ petition, which is, my lord, Lordship was kind enough to reject because of abandoned pleading. Here, my lord, they are repeatedly saying, my lord, this is order to rule 2 has to be applied. Our humble submission in habeas corpus, this is not applicable. This judgment in favor of me. Then, my lord, kindly come
So
to
where is that was considering order order 23 rule 1.
1. Yes, my lord. Withdrawal, my lord. Then, my lord, kindly come to 2001, 1 SCC, Calcutta 486.
2001.
2007, I may be excused.
2007.
1 SCC, 486. Para 8. Para 8, my lord. I'm reading, my lord, the bold portion.
Paragraph 8.
Maintainability successive habeas corpus petition, res judicata or constructive res judicata, applicability of bar.
We are not getting 2007 1 SCC.
1 SCC, page 486. My lord, we have made pagination, page 9.
486, yes. What you are saying?
My lord, para 8, I am drawing lordship attention. Successive habeas corpus petition is permissible. Paragraph 8.
Yes.
Then, my lord, I am referring, my lord, lordship knows, my lord, 2007 6 Supreme Court cases 120. 2007 page, internal page, our pagination, page 14.
Para
12.
Para
12. Here, my lord, the principle is approaching writ court, one must come with a clean hand. Honorable Court was kind enough to say, if the dart is removed, then, my lord, it is permissible. Para 12. Justice Satyabroto Sinha is the lordship.
Para 2.
12, 12, my lord, 12, 12. No, my lord, I may be excused, my lord. Para 22 also. 12 and 22. 12 and 22. Even if I have committed any mistake, my lord, I have rectified myself. I'm an illiterate lady, only knows LTI. And the devastating effect after the arrest and deportation in my family, my lord.
What you are placing? 22. Yes. How suppression of file?
My lord, in this case, however, suppression of filing of suit is no longer a material fact. The learned single judge and division bench of the High Court may be correct that in case of this nature, the court jurisdiction may not be invoked, but that would not mean that another writ petition would not lie. When another writ petition is filed disclosing all the facts, the appellant would be approaching the writ court with a pair of clean hands, and the court at that point of time will be entitled to determine the case on merit, having regard to the human rights of the appellant to access to justice and keeping in view the
Yes. Anything else?
Then, my lord,
We are
unlimited or on the question of maintainability, lordship. They are raising the question. I have filed case before the Delhi High Court, which is not permitted to file approach this honorable court. That is why, my lord, I'm trying to show. My lord, remaining things are there, my lord, international covenant and all these things that is relating to, my lord, the merit and Supreme Court and High Court are capable enough to declare citizenship. That is the, my lord, direction issued by the honorable Supreme Court pursuant to, my lord, the order passed on the last occasion in West Bengal Migrant Labor Board case.
What
Lord,
order?
directed to consider the issue of citizenship also. Not only, my lord, the habeas corpus. At the same time, citizenship issue is required to be considered. May I read, my lord, the relevant portion once again?
You have showed us.
Yes, my lord. That is my humble submission, my lord.
Thank you. Yes.
My lord, may I give reply?
Just one. Yes. Have you checked up, Mr.
Yes, yes.
This shows that there was a diary lodged by this person.
Person was relatives of the person. And my lord, it was inquired into.
Yeah.
And my lord, after the inquiry, if your lordship kindly turn to the second page of the, my lord, the
Yes.
report, the last three from the bottom last paragraph 3, that after verifying the said documents, that is, my lord, the deed, Aadhaar card, voter card, and other documents, relevant documents. After verifying the said documents, it is clear that the 3 detainees have been residing under Paikar PS in district Birbhum for a long time since their birth. As per Gram Panchayat Pradhan report, they are 3rd generation inhabitants in this area. It could also be noted that nothing adverse or criminal PS records could be detected against the detainees. In the meantime, from our side, communications have been made through email with Delhi Police Authority for the purpose of obtaining concerned documents connected to said detainees, but their reply in this respect is still awaiting. Email was also sent to the Delhi Police. Yes, yes. Documents is annexed in this petition.
All right. Yes, Mr.
And not only one thing subject to correction. Before deportation, it is expected that some communications should be made with the Bengal authorities, police authorities, or administrative authorities. Because since prima facie, when it is established that yes, they are residing over there, some information ought to have been received. So this is our submission.
Yes.
But the issues I have raised are 3. One, admittedly, there was a writ petition before the Delhi High Court challenging the illegal detention that is in the nature of habeas corpus. My lords are aware that the writ of habeas corpus, time and again, it has been decided by the Supreme Court that is maintainable only when there is a finding of illegal detention. That is the scope to adjudicate and exercise jurisdiction.
Yes.
Then, my lord, it is also admitted that after deportation, they have filed another writ petition before Delhi High Court challenging the order of deportation. We have, before the Delhi High Court, filed an affidavit disclosing the order of deportation and date of the order of deportation. And therefore, in a given facts, when 2 writ petitions were filed, and those are suppressed in these present writ petitions. Whether a poor people or illiterate people can waive all canons of law under the sun to maintain a writ petition. And if it is the presumption of malafide is also established by their purported attempt to lodge one diary at Pakur district of Birbhum after those writ petitions were filed there, suppressing also in the fact that in the diary that they have moved the writ petitions in Delhi High Court. And over and above, the officer in charge under whom this diary was lodged was not made a party. Absolutely malafide intention, right from the beginning. Thirdly, when they have withdrawn these 2 petitions, the deportation writ petition, no leave was granted by the Honorable Delhi High Court. And if no leave is granted, the law enjoins categorically, I shall be producing, if your loss is 1, so many judgments, and also Rule 53 of the Appellate Side rules that Civil Procedure Code applies in the proceedings the principles. Order 2, Rule 2 said that whenever a judicial proceeding is initiated, if all the claims are not adjudicated or pleaded, and if it is withdrawn without the leave of the court, all subsequent proceedings shall be barred. Order 2, Rule 2, Order 2, Rule 3. Therefore, they have not obtained leave from the Delhi High Court, withdrawing the deportation writ petition, and now championing the cause here, saying that this writ petition is maintainable because habeas corpus petition, the judgments they have produced. Thirdly,
Just.
It is a very short provision, your lordships are aware. Order 2, Rule 2 and Order 2, Rule 3. I made it. This is Order 2, framing of suit. বইগুলো দাও না।
CPC-টা দাও।
No, I have got it.
আরেকটা আছে।
এই যে বইটা। Order 2, framing of suit. Every suit shall, as far as practicable, be framed so far to afford ground for final decision upon the subjects in disputes and to prevent further litigation concerning them. It begins with this, to avoid multiplicity of proceeding and further litigation. Now 2, suit to include the whole claim, every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action, but a plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court. Now, 2. Relinquishment of part claim, where a plaintiff omits to sue in respect of, intentionally relinquishes any portion of his claim, he shall not be afterwards sue in respect of the portion so omitted or relinquished. I am relying on this. And then 3. Omission to sue for one of several reliefs. A person entitled to move more than one relief in respect of the same cause of action may sue for all or any of such reliefs, but if he omits, except to the leave of the court, to sue for all such reliefs, he shall not afterwards sue for any relief so omitted. There is a specific word in the provision of law. Admittedly, no leave is granted by the Delhi High Court. Withdrawing the deportation order, there is a writ petition for deportation. Here they have not come of challenging the order of deportation. Then absolutely the cause of action in respect of these two petitions as habeas corpus petition has abated in view of changed circumstances. No surviving cause of action. Therefore, they are too simpliciter, advance their argument limited to illegal detention. What is now the illegal detention? They are admitting that they have been deported. It's not denial. And in the reply, affidavit in reply, there is a desperate attempt to improve the case, which was not initially made in the writ petition.
Yes.
Therefore, as on date, the order of deportation is not under a challenge before your lordships in any manner whatsoever. And that cannot be challenged also because no leave is granted by the Delhi High Court. Order to Rule 2, Order to Rule 3, these are barred. Then Order to Rule 3 is joinder of cause of action also. There is another bar. আমি জানি ওটা. Fourthly, my lord, kindly consider. Is it their case that after deportation, they have come back to India? They have drawn your lordship's attention that they are residing in India. And even then there is detention. Nothing. The acceptance of deportation to Bangladesh. And I have cited the Constitutional Bench judgment of 61 Supreme Court that deals with two parts. One is deportation, the other is decision by the Constitutional Court about citizenship. I need not repeat that the honorable judges, 5 honorable judges, unanimously held that these are questions of fact, requires a lot of evidence, cannot be decided by the writ court. Fifthly, your lordships asked Mr. Trivedi and Mr. Kumar on the last occasion that the Foreigners Act has been repealed, but there is a saving clause. There is a saving clause.
That is September.
Yes, 1st September. Therefore, cause of action arose earlier. And there is a saving clause. Foreigners Act of 1946 will prevail for adjudication of these matters.
Arrested as by a head constable in terms of the new law.
That is not the issue. Issue is jurisdiction and maintainability. And finally, my lord, your lordships will kindly appreciate that the question of deportation can, if at all, be challenged in this honorable court. This has to be done not before the habeas corpus court, but before the learned single judge. Therefore, adjudication of deportation also cannot be made by the division bench 7 except the question of habeas corpus maintainability. Because they have not challenged deportation order. They challenged before the Delhi High Court, withdrew it without leave. Delhi High Court did not grant them leave to sue on this cause of action. And even if leave is granted by Delhi High Court, cause of action does not come back to Calcutta, because I have drawn your lordship's attention to the array of respondents. All are at Delhi. Decision whatever taken is at Delhi. Deported from Delhi to Guwahati and then to Bangladesh. Is there any whisper of any document or anything before your lordships that they are Indian citizens of Pakur and they have come back to India? Which- Therefore, my lord, my lord, the officer in charge of Pakur is not a party. No, nothing has been disclosed. No voter ID card, no other card has been disclosed. And this has not brought to the notice of the Delhi High Court, that this cause of action survives in Calcutta because they have lost a diary in Pakur. Nothing has been done to their lordship's court. Therefore, it is issue estoppel. Doctrine of issue estoppel applies. And a case of forum shopping, I have already said. Supreme Court time and again deprecated this practice of forum shopping. And if my lords find, I have already submitted on specific relief act. If the conduct is bad, no relief can be granted. What is the conduct? These are my submissions. And my lord, no distinction has been made to the judgments referred to by me that these are not applicable.
Lord, only one thing, Lord, with due respect to my learned senior friend, but one thing, Lord, I can submit. But the allegations that
Yes,
after the Lord, the withdrawal, suppressing all and mechanical mechanism is very nice. They lodged a complaint, missing diary over the police station. Blood, assuming but not admitting. Blood, after verifying the documents, email has been sent to the Delhi administration. But till today, why they did not answer? But I am questioning myself.
State is exposing the cause.
First report, last paragraph. I have second page, my lord.
Yes.
In the meantime, our said communications have made through email with the Delhi Police Authority for the purpose of obtaining concerned documents connected to said detainees. But their reply in this is still awaiting. Is it the fair part on the part of the Delhi administration?
Lord, what is the date?
Yeah, no, I am not disturbing you, Mr. Chakraborty.
We are not going to the merit at all. And kindly appreciate what is the date of lodging the diary. Whether this is malafide or not. After 2 writ petitions were filed in Delhi High Court, having been absolutely miserably failed there. May I leave?
My lord, in item number 3, my lord,
Yes,
I am appearing for the mission, my lord, led by Mohammad Sarwajan.
you have filed it.
Yes, my lord. In the previous occasion, your lordship is directed to file the report. No, the report is. Yes, my lord.
Well,
Thank you.
let me have a copy, and I have not just received now. Now, my lord, kindly give us some.
My lord, may I say one thing, my lord? In this report, my lord, she is entitled for only 1 lakh, my lord. Yes, my lord. And already she is received. Oh, sorry.
Pursuant to our earlier order,
But in this matter, yesterday your lordships expressed your lordship observation and the desire. Yes,
told her that
expressed and desire. But I have also persuaded the chairman School Service Commission, and he has issued the admit cards.
the credit goes to your daughter, Mr. Mohan.
Yes, yes. He was very shaky. Yes, yes, yesterday she was telling me I was at Delhi. আরেকটা কপি আমায় দাও।
Then what do we record, Mr. Mohan?
But that in terms of the in terms of the order of the single judge, the School Service Commission has carried out the order and issued the admit cards. Therefore, appeal has become infructuous. That should, that's a suggestion. And in fact, today I have given consent at least 10 to 12 candidates on that before the single judge.
On the same issue. Same issue.
Same, different,
Similar.
difficult, but
Different cause of action in one petition.
I have given the consent. All right, all
No,
right.
that is because you are not there. We requested her to talk to Mr. Bandyopadhyay so that because order which has been passed, Mr. Bandyopadhyay said that there are some infrastructural problems. That was told her. But we requested as to whether so he has that is a good gesture also.
order dated 10.
Lordship, in this matter, Mr. Shantanu Kumar Mitra is appearing for the state respondent, Lordship. Lordship, few days back, he has gone through a eye surgery, Lordship, and he's facing some discomfort in his eyes, so he could not come to court today, Lordship. I'm taking for only not today.
Respondent now. I believe, my lord, what I have heard, my lord, now I am the answering respondent who has to, my lord, oppose the application under Order 41, Rule 1027 that has been brought on record, tried to be brought on record by, my lord, for adducing additional evidence in connection with this appeal. I have taken out an opposition to that.
That is Taposhi sheet.
Taposhi, this is that
Number
5 and 6.
After
Your worship keeps it, my lord. If they want to, my lord, use an reply to that, kindly, my lord, that, my lord, my instructing advocate has, my lord, said that they have chooses
you have filed an
opposition to, my lord, Order 41, Rule 27 application. If they chooses not to, my lord, file reply, then, my lord, it's their choice.
Argument has already been concluded, my lord, in this matter. Mr. Surojit Nath Mitra, my lord.
No, once
was on one facet of it argument.
My lord.
Then at last they came up with certain documents. We have not heard Mr. Shanmal on that.
On that, my lord.
Shanmal
Yes, my lord.
Yes, my lord.
For them, my lord.
Mr. Shanmal is leading me.
Leading them, my lord. We are lead by
Since
Mr.
now
Surojit Nath Mitra.
4127, my lord, I have been brought on.
My lord.
You have filed the application.
No, my lord, it's the appellant who have filed the
The application, my lord, incorporated some documents, my lord, which is relevant, my lord. My lord, the point was raised by them.
I have taken, my lord, threefold of legal submission, my lord, which I want to canvass, my lord, in my opposition. Reply দেবে না তো?
They have filed the opposition, my lord.
Do you want to file a reply?
You want to file a reply?
My lord, no, my lord.
Then record that, my lord.
No, my lord. Earlier occasion, my lord, we have said it.
But if you don't
Very well, my lord. Very, very.
why you are taking the responsibility?
Very well, my lord.
in record. Yes, my lord, I am challenging the order, my lord, 14/7/2005, single bench order of the writ petition.
Who are you?
I am for the appellant.
No, you are the teacher in charge.
No, my lord, I am for the appellant, my lord.
You are
At first, I have filed a writ petition WP number 6774 of 2015.
what post you hold in the school managing committee?
This is a sanction post, assistant headmaster post.
How can you be assistant headmaster? Assistant headmaster approval is by given to this Parvez.
Parvez Chaudhary was
Where is your
according.
service? You have completed service.
Yes, my lord, I have.
They have received. Have you checked up?
My lord, almost received, my lord. Service resolution.
পার্টি না
Service resolution.
পারভেজ চৌধুরী রিটে
Thank you.
ফারুক তো অন্য একটা রিট ফাইল করছে WPS 674
You were added to Parvez petition.
Yes, my lord, I am not added, my lord.
Then how can you file the appeal?
My lord, regarding this, I have, according to the advertisement, my lord, I have made an application. My application has been rejected.
On that, you have preferred appeal against an order passed by the single judge in a writ petition filed by one Parvez. In that writ petition, you are not a respondent. So how can you file the appeal immediately? Stamping order to the
একটু খেয়াল করেন
state করেন। How can you file the appeal immediately?
Yes, my lord, there is a writ petition, my lord. There is a writ petition filed. There is a writ petition, my lord. At first, there is a writ petition in this writ petition 2015 6774. There is a party of Parvez. Parvez Chaudhary is a party. There is.
That does not help you.
Are you party in 11669?
6774 of 2015.
Oh, are you party in WPA 11669?
No,
You're
no,
not
my
a
lord.
party. You have preferred the appeal in
This
which
writ
date?
petition not hard, my lord. This writ petition not hard.
Who
There
is
is
your
issue.
senior?
There is a issue.
Who is your senior? Anybody else is appearing?
No, my lord. There is no. Not hearing. I was.
Lordship, I'm praying for a very short pass over, Lordship, on behalf of the state,
Kindly,
being
my lord,
led by Advocate Radoshi Basu, Lordship.
My lord, give it 1 week time, my lord.
Sir, you have to anyway. In that writ petition, you are not a party.
Not a party.
So, without being a party, if you want to challenge that order, you have to file an appropriate application.
Yes, my lord, I have made an modification application. There is a
আবার
request.
মডিফিকেশনে হবে না, you have to take leave from us.
Leave, my lord, there is without certified copy, I have pray leave before the honorable court. After taking leave, my lord, I have.
We are unable to make you understand. You decide what you do. Then without that application, we cannot take up the matter. You are not added as a respondent in the writ petition, so you cannot directly file an appeal.
Kindly allow me for leave, my lord, allow me for filing.
1 week adjourn করে দাও।
Leave to file.
You please ascertain, apply your mind, take appropriate steps. Yes, next.
Lord, item number 8, Lord. Lord, I have instruction to appear in this matter, Lord. I pray for not this week because, Lord, the change brief I received yesterday, Lord.
You are for the appellant.
Appellant, I received the brief, Lord, yesterday, Lord. I pray for not this week, Lord. Monday I can do this.
Lordship, there was a direction for filing affidavit in opposition in this matter, Lordship. Lordship, it will be affirmed by today, Lordship. I'll serve them a copy.
Any urgency? Lord, keeping it after vacation. You file your reply. Your name is not there?
No, Lord, I received the no objection, Lord, yesterday night.
Oh, acha, acha.
My
You
Lord,
have got the supplementary affidavit. You have filed the opposition, got the opposition.
No, Lord,
Lordship, it will be affirmed by today, Lordship. I'll serve them a copy by today only, Lordship.
You are Mr.
Amartya Pal.
Mr. Paul Paul, learned advocate.
I'm for the appellant, my lord. But I cannot move this matter today because, my lord, in the Sarthak is been served with an intimation that it would be moved on 19th.
19th.
19th. So, my lord,
19th. Yes, next.
For the respondent writ petition.
Respondent writ petition. Who is the appellant?
Mr. Sen and Mr. Bhaskar Prasad Boisho, Amol Kumar Sen and Bhaskar Prasad Boisho, appearing for the appellant.
Where are they? You have again adopted any resolution or what? Nobody is here?
No, there is no resolution.
Oh, there is.
Sorry,
I'm কোথায়?
কোনো লিস্ট অফ বানিয়েছি?
বানিয়েছি, পরে আসছি।
This for final hearing, Mr. Sir?
My lord.
Paper book হয়ে গেছে?
My lord, this is the, my lord, almost, my lord, paper book because, my lord, all the documents that has been, my lord, annexed here too. Because the documents, may I tell, the copy of the writ petition, and the orders which were relied upon by the, my lord, the code
It was
below.
hard by a coordinate way.
Yes.
Matter was hard.
My lord.
Hard and my lord, the hearing was
My lord,
concluded.
in fact, hard judgment reserved. Then, my lord, after that, my lord, again.
আগের দিন তো কনফিউশন হয়েছিল, শুনিয়ে বলেছিল।
Oh,
But after that, my lord, it fell from your lordship that after inquiry, my lord can.
here, justice standard, once it is notified, my lord cannot see. But there is a statement in this
The regular
No,
bench
that
can
was
hear this
that was a regular bench, and my lord is a regular.
Regular bench
That
can
is-
hear this matter.
Regular bench can hear.
There was no notification regarding.
Who is, my lord, is that in 2013 a special bench was formed on the, my lord, to decide an issue that in terms of, my lord, the ROPA, when a particular provision in the ROPA amended, then whether the teaching and non-teaching staffs of the, my lord, the institution, they should be given an opportunity to put their option with regard to certain, my lord, financial benefit, including the, my lord, the pension. Now, the special bench, my lord, it was held that yes, the government, they should give an opportunity by way of publishing in the newspaper that option should be invited, and if, my lord, the persons concerned, they respond to that, then they have to refund their provident fund money, whatever form of the employer's contribution. And from the date of, madam, may I tell one thing? Rashi, kindly, madam. The first special bench order was that they are, yes, Abhijit Boiddo, that they are entitled to pension from the date of the refund of their respective that provident fund sum with interest. And that too within a certain period, an advertisement was there. Notification was that. Now, my lord, it was complied with by both the parties, by the, my lord, the beneficiaries, as well as, my lord, the state complied with. So that chapter was over. That after refund of the provident amount with interest, the government, they disburse the or my lord, release the pension amount of all the beneficiaries. So that chapter was over. After that, in 2019, again the special bench was formed, my lord, to adjudicate an issue that with regard to that normally after the date of retirement or after 1 month from the date of retirement, the employee is entitled to pension. Whereas in Boiddo's matter, the special bench said that no, judgment was there from the date of refund. Suppose, my lord, suppose one respective employee or teacher, my lord, he retired in 2009 or 2010. In terms of Boiddo's judgment, my lord, he reported the employer's provident fund sum 2014 or 2015. Then he was entitled to pension from the date of refund, not from the date of retirement. Then the second special bench was formed in 2019. There was the issue that why this departure from second special bench said no. Whatever you received, whatever paid, paid. But the issue is now in regard to that interagnum period from the date of retirement of each individual to the date of refund of provident fund. 4 years, 5 years gap. The special bench, second special bench said that they are entitled to from the date of retirement till the date of refund. That means that 3 or 4 years gap.
That period has to be paid.
That period is to be paid the pension. No difficulty. But the difficulties arose.
These are in respect of the teachers who were.
Yes, yes. So, my lord, what happened?
Not family pension and everything.
No. So, what happened? what happened?
Then what happened?
No, family pension naturally, my lord, include that if somebody died, then
No, the applicants were not the widow.
applicants, no. Now what happened? Now, so far this second special bench judgment was concerned, there it was specifically mentioned that a particular paragraph of the earlier special bench judgment of 2013 is being modified to this extent. We are not touching anything further. So all the, my lord, the direction, observations remain.
Then what happened?
Then the second special bench said that paid this amount. No interest. No interest. Paid this amount. Now, what happened? This 2019 special bench judgment, after having been passed, then, my lord, somebody applied because they have to, my lord, there are some technicalities.
Applied for what?
Apply for that, my lord, the balance amount.
That retirement till
Date of retirement, yes. Then they have to, my lord, because the technicalities are to be followed. Now, some, my lord, after 1 year, some 2 years. But in the meantime, what happened? After the 2013 judgment till 2019, first special bench judgment and the second special bench judgment, my lord, all, my lord, not less than, my lord, 100 writ petitions or more were filed. And they, in their individual writ petition, actually they paid this particular, my lord, the period's pension with interest. With interest. Now, all the writ petition disposed of, directing, my lord, by the single judge, whenever it came up, that pay the said sum, but
interest will be decided.
no, silent. Paid, interest paid.
Now, what is the problem?
I'm coming to that. Now, the problem is that after this third special bench, second special bench judgment, again, all those writ petitioners who earlier moved this court, who prayed for this interregnum period of pension with interest, but their interest was refused. After this special bench judgment, then again they filed their individual writ petitions and prayed for interest portion.
But that the second special bench
Has not said. No. They again said that interest.
Then what happened?
And my lord, all more than 100 writ petitions, my lord, were taken up by the impugned judgment disposed of. Common judgment, which is before your lordship. Yes.
Said give interest.
And said give interest from the after 1 month of the special bench judgment of 2019. But I have to be very frank, my lord. These writ petitions were disposed of by a common order of the impugned order that pay the interest. Suppose, my lord, in November, pay the interest on that area sum of that interregnum period from date of retirement to the date of refund, though my lord, the amount already paid or not, but from 2019, the order was passed, so pay that area sum. So you pay interest from that date. We are before your lordship that interest
That is contrary to the second special bench.
is our contention is, my lord, twofold. First of all, it's a case of res judicata. In the single bench you prayed for, single bench did not. So section 11 explanation 5 applicable. Second thing is that the special bench, when the special bench of 3 judges bench thought fit not to pass any order on the basis of the interest quantum.
Contempt preferred.
No.
Contempt.
One contempt order filed not by the writ petitioner. আমি তো ফেস করছি but lordship petitioner is not filed any contempt application, but one writ petition filed a contempt application in the trial court. I am requested the division bench matter is pending. Lordship, the matter is out of the list. Trial court say matter is out of. One contempt petition is filed, lordship.
Can you file a short paper with Mr. Sen?
If your lordship guided, I shall file paper. My list of dates are ready.
Son, giving liberty to file a
Lordship, kindly pass on order, my lord, restrain them from, my lord, pursuing any contempt proceeding. We are ready, lordship, kindly give it. No,
Uh,
no.
This is only
Writ pe-
one appeal,
One appeal.
but the 100 writ petitions.
But
clubbed
I
together
can
by a
satisfy your
common-
lordship.
by
Here
a
and now
common-
there is a, my lord, the
common
latest judgment that when the issue is same, my lord.
One appeal will suffice.
Yes. Say, latest judgment of 2022.
You are not opposing. Are you
No, no.
opposing?
No.
You are which petitioner?
First petitioner, Swapon Kumar Chakraborty. No, not only first petitioner.
Any petitioner.
Next.
But same issue was, my lord, taken up by the Supreme Court, and they said that,
It's already on record.
my lord,
We are fixing for final.
And because most of the writ petitioners, my lord, above 80 years old, 75, 80 years old. They retired 2003, 2005.
We have been advised by 2.
হ্যাঁ item number 9 my lord wrongly সার্থক department wrongly type my lord 19/9/2025 হ্যাঁ এই ডেটটা ভুল করে সার্থক করে দিয়েছে না স্যার জানতে চাইছি হ্যাঁ যেটা আজকের ডেটে মামলাটা হওয়ার কথা হ্যাঁ সেটা ভুল করে ওনারা ভুল দিয়েছেন বলে জজ সাহেব সেই 19 তারিখ দিয়ে দিয়েছেন 19 তারিখের মামলাটা হবে না রবিবার না করতে পারলে কালকের মধ্যে মামলাটা নষ্ট
কি হয়েছে নাকি তোমার কি তুমি কে জাস্টিস
আমি পিটিশন
তুমি পিটিশনের কি ক্লাস 9 10 কি
And what is the problem?
Problem is that when she has gone to Malad give the copy of the stay application to the learned government pleader, government pleader office has endorsed that it will be coming on 19th.
Yes, that was what.
No, my lord. Wrongly.
Mr. Sarwar Jahan appeared.
Yes, my lord. This is the actual.
Yes,
my lord.
When have you
main terrorism you have not served us. কি চেয়েছো ওটাতে
চেয়েছি স্যার পার্টিসিপেট করতে
টেন্টেড নো তা কি চাইছো সাবজেক্ট চেঞ্জ
আমরা হ্যাঁ
সাবজেক্ট
তার দিকে আমরা যদি
এখন হিয়ারিং চলছে 14 তারিখে পরীক্ষা বসে
told to us that mistakenly
Yes, my lord.
it should
19.
appear on 19.
Yeah, no, my lord. This is the original.
So very good. That was not told to us. So when it is there, we will take it up tomorrow. That's it.
give us a copy of the to the SSC huh give it to us give it to him but that is all are tainted covered by your
10th July এর order 10th July এর order
problem you have a copy this কার হয়ে অ্যাপ্লাই করছো
petitioners
was filed, we gave him time to file request. But when we went to sign the order, we found that
Last occasion we have all yes.
So we have simply heard you and we have elected it. Please inform that to
Mr. Kamal Mishra.
No.
সৌরভ মিত্র আর
I'll meet.
স্যার আমার জন্য এনেছেন কালকে বললেন যে পেনের পাউচ আনবেন
আমি ওই বাড়ি যাই
you concluded.
But given the owner has tasked me on the last occasion, would have tried to find out a solution in my own way, but I shall come to it. Your lordships are required to take into consideration two orders passed in these proceedings. But one is dated 13th of September 2022 in connection with the writ petition.
Your argument was last date you said you showed us the regarding publication.
Yes. Now, we stopped at a stage where your lordships were pleased to take note of two distinct panels insofar as the trained and untrained are concerned.
And then your lordships were pleased to observe. Not a trend. I mean, yes, trend and untrend.
Composite.
Now your lordships were pleased, at that stage your lordships were pleased to observe what happens to the trained candidates then. In the event it is found that there is no aptitude test.
But for the Can 5 applicants.
Yes, not there. I appear for the writ petitioners. Some of the writ petitioners.
Petitioners in
WP number ta bolo.
petitioners in
Priyanka Noshkar. 2117.
Math bol na.
Mat 873. Mat 873.
you are applying for the respondent requisition.
Yes.
কালে অন্য ঘরে চলে চলে যদি তো ক্যাচ করে ধরবে
Arising from WPA 21187 of 22.
That is the writ petition.
There's a writ petition.
But the respondents in the appeal of 87.
My lords.
And also you are appearing for the applicants in Can 5.
They were also writ petitioners, but they were not at that stage.
You were also writ
Yes, no, their applications have already been allowed.
Copy not
What
never
for
served
the-
up.
অ্যালাউ হয়েছে না
Their applications for addition of impleadment has already been allowed.
So why you are saying they are also writ petitioners? They wanted to be added as parties, Can 5, and they were added.
It is separate writ petition. They were separate writ petitioners before the Honorable Single Bench. Since this,
Which writ petition? There are 140 writ petitioners in the writ petition WPA 21187 of
yes,
20.
এই পাঁচটা হচ্ছে রেপিটেশন আমাদের হচ্ছে এটা
one was being heard. So the other parties wanted to join in the appeal so that in the event the appeal gets disposed of, there was no point in hearing.
Writ petitioners you were appeared.
Separate writ petitioners before the Honorable Single Bench.
November 143 but
Oh, you filed separate writ petitions.
There were 5 sets of writ petitions.
That was adjourned.
Those
were not decided.
4 were adjourned sine die.
এই জন্য 873 রিট পিটিশনে এসে ওরা অ্যাডিশন অফ পার্টি which is why you preferred addition of party in 873
In the event this appeal gets disposed of, they would
your addition of party was allowed
by an order of date ta bolo.
26 September 2023
4th September 2023 these applications were allowed.
4th September
Versus Can 5 of 2020.
Can
5
Can 5
and 6 or 7
Can 6 and Can 7.
and can
But I've got note that they are mentioned not in the order. If I can handle.
But in the main appeal, I am appearing in this matter. Cans have never been served upon us. Number one. Number two, if they have been added, then the cause title has to be amended. Cause titles have not been amended.
What we intended, because there are 600, 700 persons. Whatever judgment we deliver, that will be rem applicable to all the persons.
No, I am on a very
For amendment of the cause title, you can send it back.
no. It in appellate side, it can be done here by the advocate on
How
request.
many persons will be
That has to be. They have not given the applications to us. Otherwise, let's just
application to disposed of.
they have not they have not served it and they have got it disposed of. That time bundle.
They don't want to give it.
No, only technical things should be, my lord. These things should not be here. It will go up. Then cost title would be defective. No one would be able to prefer SLP.
So why is we will indicate in our judgment.
Your lordship should indicate your lordship's judgment, but parties have to be made now. In the Supreme Court SLP, it has to be stated the description of the parties.
Then we have to check. Was there any deduction for correction of cost?
No.
No.
But what we can do, not after hearing of this matter, not we can enclose a separate sheet as is normally done in case of a large number of parties being added.
No, there are.
No, I have learned this thing from Mr. Vikas Bhattacharya.
Have not been done.
Those who have been allowed.
Malad,
Those who have been allowed.
Would your lordships kindly remember one thing? Just I tell your lordships, I was moving an appeal. Mr. Bhattacharya said that the parties have not been added. Your lordship was sitting in that. Then at the time I said that yes, let me start it. When I will finish, I will give the list. Can you remember that matter? When I ended, then I have given the 640 persons list, and your lordships have amended that. My lord, Chakraborty, I am saying, just say Chakraborty. And that was the point of Mr. Vikas Bhattacharya. Now I am taking that. Yes. All that, these technical things can be resolved, but
Not in relation to the writ petition,
Can 5, can 6, and can 7.
not I have indicated in pencil, not in relation to which mat number those applications have been filed.
Sir, writ petitioners,
They are the writ petitioners. 4 separate sets of writ petitions were pending, which were adjourned sine die, awaiting the outcome of the writ petition.
So those have not been disposed of.
Those have not been disposed.
Can you give us that order when it was
Yes,
adjourned?
Yes,
exactly.
চট করে বার করে বলো।
Yes, you proceed.
Two orders are necessarily required to be considered by your lordship's court. One is dated 23rd of September 22. Down now.
September, 13th September বলি।
আবার
অর্ডার ডেটটা ঠিক বল সম্ভব।
ঠিক না?
তুই একবার 13 বলছিস, একবার 23 বলছিস।
23ই তো বলছি, প্রথম থেকেই 23।
এটা আবার কি দিন?
23rd September 2022.
এটা কি? আমাদের দে। কিছুই তো দিচ্ছি।
September 20. Very good. Yes.
ওরা কিছুই দিচ্ছি। They will not give us only, my lord, only your lordships can give us something, and they will not give us anything.
They have got everything.
I
They are the haves, we are the have-nots.
চল আমি যাই।
Sir, please come to page 89 straightway.
আমাদের কি
Order of 23rd September 22. No, it is a compiler, it's a convenience brief. It's a convenience brief. Contains
convenience.
তুই রাত্রি 12:45 তুই বলেছিস দেবো।
How many convenience
Convenience one.
Please come straightway to 89.
Sir, এটা কি দিচ্ছে আমাদের? With your lordship's leave, I am going, and your lordships will not be disturbed if I go there. But
59 of convenience brief.
Order dated 23rd September 22.
Yes.
It's an order dated 23rd September 22.
Yes.
Please turn over to page 90. Learned advocate for the board has submitted that for uploading the breakup of marks for all empaneled candidates in respect of selection process of 2016 and 2020, the board needs time till 30th November 22. Learned advocate for CBI and learned advocates for the petitioners have agreed to that, and therefore the breakup of marks has to be uploaded in the website of the West Bengal Board of Secondary Education so and so. If it is done, then Please see, they will intimate the fact to the other learned advocates for the parties. Before that is before 30th November 22, Mr. Banerjee will intimate the fact to the other learned advocates for the parties. Now, please come to page 92. The next page. 29th November 22. In compliance with the order of the Honorable Justice in WPA number so and so, the West Bengal Board of Primary Education has published breakup of marks of TET 2014 qualified impaneled candidates against 42,949 and 16,500 vacancies respectively on 28th November 22. Upon publication of such lists, it has come to the notice of the board that there are errors or anomalies in the published lists. Since the board is going to hold the teacher eligibility list 2022 on 11 December 22 throughout the state, it will take appropriate steps for removing such anomalies or rectifying such errors after 11/12/22. Further notification in this regard will be uploaded in the board's website.
Yes.
But even thereafter, the correct list did not surface.
Where from this 16,500 come?
Subsequent 22 process.
2020 recruitment process.
State.
20, matlab this is relating to 2016 recruitment process, 42,000 and odd.
The first one is for the 2016 process.
And
the second 16,500 is for the subsequent process.
2020 recruitment process.
For which
Not
the
subsequent.
examination was scheduled on 28th of November 22, something like that.
Not subject. What you are trying to point?
But there is no finality of the panel or list.
It's not a panel, the breakup of marks.
Right? The list, upon publication of such lists, it has come to the notice of the board that there are errors or anomalies in the published lists.
So then how that is prejudicial?
So there is no finality attached. There could not have been a finality attached to the panel.
Relating to breakup of marks of late 2014.
In compliance with the order of so and so, passed on so and so, the board has published breakup of marks of the TET qualified impaneled candidates against those vacancies.
So maybe that is not the panel for this selection.
2016 selection process.
State 14 eligible, then you participate.
Right.
So state 14 breakup of marks, you are saying that there were anomalies, they themselves had.
Not TET 14. No. The court wanted public uploading of the results of the 2016 selection process.
That is state 20. That is a state exam.
No. 2016 recruitment process for assistant teachers.
Breakup of marks.
Yes. Breakup of marks in TET 2014 was not required.
Yes, so this is a, since the board is going to hold TET 22, it will take effort for removing anomalies and the rectification after
Vacancies. Vacancies not in relation to filling up of vacancies of assistant teachers in a subsequent process of recruitment.
Yes.
Upon publication of such lists, it has come to the notice of the board that there are errors or anomalies in the published list. I'm sorry.
After date 14, when was the next date hit?
2017.
27. So this notification you are trying to highlight that there are anomalies.
In the published lists of candidates who have been impaneled in the 2016 recruitment process.
That we do not find.
Please read it once again.
Yes, read it.
In compliance with the order of the Honorable Justice passed on 23rd of September 2022.
Published breakup of marks.
Yes, not breakup of marks could not have been for TET 2014. Breakup of marks could only be for a recruitment process for appointment in.
That is your argument.
It can't be. No, please come to the rules then once again.
This is a breakup of marks for TET 2014.
Can't be. TET 2014 qualified.
What has been stated.
Please come. Qualified empaneled candidates against 42,949 vacancies. Vacancies is not in TET examination. Vacancies is in relation to.
May I just assist your lordship? My lord will first kindly come to the.
We are asking for this assistance for 4 weeks, Mr. Bhattaji. Every time we say you call Mr. Bhattaji, let him argue finished. Because
But-
you covered all the points.
As I am told, I am here. The 20th November 2022 notification by the board, that will clarify the subsequent one. 20th November 2022. This is a part of the proceedings. কোথায় আছে বলে দাও?
Can 70, page number 204.
Allow no record দেখাতে আপত্তি কি? But that is a part of, my lord, this is primary education department's record. Nobody can dispute. That is a part of Can 2.
Can 70 also. Can 74.
What is your argument?
Lord, I just reading out, to be clear. My lord's query would be answered. It is hereby notified that all notified to all concerned that in compliance with the solemn order of the Honorable Justice Abhijit Gangopadhyay passed on 23rd September 2022 in WPS Wanso, the West Bengal Board of Primary Education is uploading the breakup of scores of TET 2014 qualified empanel candidates against 42,949 and 16,500 vacancies in 2016 and 2020. List is enclosed. And recommended them to the respective district primary councils for appointment. Therefore, this was the final, my lord, the list for appointment. And that was subsequently modified, saying this is not correct. Therefore, we
Yes.
Now, please turn over to page 98. But in fact, in the first few pages, your lordships will be pleased to find there is in the form of list updates, the events have been capsulated. Page number 4 of that brief, your lordships please take. Second entry at page 4. Remember, the relevant document is at page 98. 11th.
11th January is not accurate list of dates.
Yes, but kindly permits me. This
Proceed. We are in page 90. What you are wanting to say?
please come to page 98.
98.
Yes.
Yes, tell us.
Forwarding the list of 139 petitioner candidates along with the breakup of total score of TET 2014 along with the breakup score of the last empaneled candidate in the respective medium category and district who participated in the recruitment process of 2016. So this was the first disclosure of marks in 2023 in respect of the petitioners who had participated in the 2016 recruitment process, and the Honorable Court had also directed, also indicate the marks district-wise, district, medium-wise and category-wise being the last empaneled candidate.
Yes.
Now, the flawless list has still not seen the light of the day. Very unfortunate. I'm not, for the time being, but I'm not troubling your lordship with the provision, the exercise undertaken under section 165. Please come to page 119, which is part of the board's affidavit in terms of the list of interviewers. এটাও মিলবে না। I'm sorry, it's page. I'm sorry, kindly permits me only one. ছেড়ে দিই আমরা ছেড়ে দিই বসে পড়ি আমি
So your ultimate argument is that the list which was published pursuant to the subsequent notifications, those are admitted by the board to be filled with flaws. Now the rectified list has not seen the day. This is your argument. Yes. Proceed on the next point then.
No. Not in, so far as the aptitude test is concerned, please have a look at page 367 of the spirally bound documents. Not that is part of the board's affidavit.
Which one you are showing?
Not affidavit in opposition of the board.
Yes, that we have enclosed here. Affidavit in opposition
Mentioned.
board to the writ petition.
Yes.
In 21187.
Yes.
Have you annexed that in the books? This book.
Not in that book. Otherwise, it would have been very voluminous. Not it would have been inconvenient to handle.
Page 120. Yes, it's which page you are showing?
Page 367, volume 2. That's the stand. Now please come to 367. Paragraph D. This is also part of the opposition used by the board. Your lordships wanted what were the guidelines for aptitude test? The last occasion.
Oh, yes. It may be used by. No, this was an affidavit called for by the court showing that what is aptitude test,
right?
Experts' opinion,
Right.
etc.
Right.
Those were the. So what you are trying to show?
Not the guidelines, not which were ought to be followed in the aptitude test.
Which may be used.
Right.
Not ought to be followed. Which
may be used by interviewers for assessing the aptitude of prospective primary teachers are as follows. Right. But they have stated that none of these were followed in 2016, for the first time followed in 2020 to certain extent. So 2016 there was no aptitude test.
Yes.
Now, on the last occasion, I have shown to your lordship in the categorical stand taken by the board that the panel had not been published. Please come to page 388 once.
It was said panel published.
No.
11.
Please come to paragraphs 8, 12 and 18 of the writ petition.
Yes.
Please come to page 38, paragraph 10.
First line number to the open. That was declared.
690. Digit.
Please come to page 38, paragraph 10. Your petitioner states that after the notification, the procedure was started for appointment, and from October to December 2016, the interview and verification process started. And on 31st of January 2017, allegedly the result was declared, but there was no panel. There was no merit list. There was no category-wise merit list. No division of numbers or rank was given to anyone. In website of the board, there was a dedicated space where a person could see whether he or she was impaneled or not. No merit list was ever published, and in spite of repeated requests, the full merit list was not made to the public. Allegedly, it was stated on 30th of January 2017, list of trained candidates were published on 4th February 2017.
Not on. There is a full stop.
Full stop.
Allegedly, it was stated.
Allegedly, it was stated.
Stated that list was not published. Now the same person says
On 4th to
December, list of non-trained published, 8th February, list of
list,
published.
list, not panel.
List.
List is not panel.
That is now yours. Yes, all right.
List of non-trained candidates and candidates from Bengali medium were published. From the dates and the list, it is clear that all trained candidates were appointed through the first list. And after completion of the same, as per notification of 2016, the board appointed non-trained candidates. The board stated that they shall publish more lists, but those lists were not published. Please consider this with the
No definition of list in the
no. Please come to the
panel has been.
yes. Please
Your statement that no list was published.
no panel was published.
That he has not said.
Paragraph 10, the first part.
Does not tell you. If you read the entire paragraph, that is your argument. Maybe.
Please come to 389 now. The board itself accepts.
Yes. 380.
With reference to the statements made in paragraph 10 of the said petition, I say that the applicable recruitment rules of 2016 made in exercise of delegated legislative power by the School Education Department, Government of West Bengal, never mandated the answering respondents to publish in public domain the panel, merit list, category-wise merit list, breakup of marks, rank of candidates as contended in the writ petition. The recruitment rules of 2016 has not been challenged in the said petition. Such being the position, the answering respondents cannot be faulted not to have caused publication of the above in public domain. However, I'm sorry.
This was argued by your others. We will seek the answer of the board on that. That we have taken. So you can proceed to other points also.
So, the next sentence is, however, in terms of the directions, the answering respondents on 20th November did publish the breakup of marks of candidates who were recommended for the recruitment process.
And which was also faulty.
Which was also faulty. This possibly takes care of not the argument advanced on behalf of the appellants in support of their contention that the writ petitions were barred by delay. And this was not instituted in this honorable court.
We were told that the panels were stuck up in the walls of the respective council offices.
We go by the evidence on affidavit before.
What is your statement? Was there any such panel published? Pasted?
Public domain would also mean pasting in at a conspicuous place. They say that it was not required to be published on public domain. Not given the best credit to their argument in the new avatar.
Anything else, Mr.
So the sanctity and requirement of publication of a panel has been considered by your lordship sitting singly in one of the education matters.
Requirement article 14.
Single bench order. I am with my brother now.
Not judicial conscience is always not judicial conscience is always enriched by practical wisdom.
Yes.
No. Not,
we accept your that there was no publication of panel in public.
so not the first limb of the submission that writ petitioners were delayed in approaching the court, or that the writ petitions were filed.
Publication, faulty publication, if at all anything was on 23rd November 2020. So delayed as well.
Number one. Number two, there is no valid panel prepared even.
Yes.
If there is large scale irregularity or illegality in the matter of the process, then not the Honorable Supreme Court in the matter of SSC, the 9-10 to 11-12 cases, in paragraph 43 has clearly held that delay, laches or acquiescence principle will not apply. Not the secondary, the Supreme Court judgment, 3rd April 2025. I just pointed out to your lordship.
Why you are taking us to that?
Only for that purpose that it has specifically observed that the principle of delay or acquiescence will not apply in a case where there has been violation of or irregularities.
Yes, that has been said by the Supreme Court earlier also.
Yes, ma'am. Now, not the third limb. And what
that was that Indrojit, 3 judgments were delivered pertaining to NEET.
Yes.
In 2 NEET judgments, the entire process was done away with. But in one judgment of our ex-Chief Justice, in that
selection was not
touched.
Not, in fact,
Please go through that judgment. There is a 3rd judgment on this issue.
there are orders passed by the Honorable Court also. Not, of course, not by the division bench.
That
Not justice, equity, and good conscience. Not protect whatever has been done. Since there are vacancies, give appointment to the waiting line persons who have approached the court, and create vacancies even. Because there are available vacancies which are sought to be filled up and which have not been filled up.
So you will be happy if you are given appointment on those.
And I am happy with that.
How will you be happy? Because you have brothers on your line.
That
Come with the
there are 550 writ petitioners.
9 vacancies.
There are 550 writ petitioners, 566 writ petitioners,
How they will be happy?
369 vacancies, and your lordship's court had directed that in future vacancies you accommodate.
That will be, I delivered that judgment in
Not only your lordship, there is another judgment.
Howrah District Primary School.
Yes.
Not 24 district primary school, your lordship. Near Vishwas matter.
And they were appointed.
They were appointed.
It all things can be eased out if the authorities don't change their avatars. Taking
all your challenges go.
I have come for appointment. There are 3.
What is the total remaining untrained candidates?
550 writ petitioners, 550 writ petitioners, 566 writ petitioners.
I'm not saying that. Thousands have appeared.
There are 3 ways not in the circumstances. Number 1, if there is a faulty question or a faulty process, the court normally follows the practice of awarding 5 marks to those candidates. Suppose there is a faulty question. So give 5 marks to the aptitude.
Where from you are saying that there are only 550 persons left.
Read petitioners.
140. 140.
No.
Read petitioners. We are 140.
There were 4 read petitions. 140 is being taken up.
We are 1. No, it's only one. What is the residue petitions was decided? Thousands.
There are read petitioners were for 556 or 566.
That means, yes, suppose today we reject that in view of this such things, problem will be solved if their appointment can be protected and you give appointment to the remaining persons. Now this remaining persons is much above 389.
389 is the 369 or 89 is the existing vacancies. There are also vacancies for which not process is.
Give us the figure now. Tell us that these are the remaining persons who have not been appointed. That will be more than 1,000. People are still waiting to come and join.
Participants were 1 lakh and not.
What is the residue amount of unpaid candidates? Apart, how many persons has approached this court and what is remaining?
The count of read petitioners is 566. 5 read petitions. And I'm not on the can, I'm only on the figure of read petitioners.
Because 1,85,000 parties.
5 read petitions were pending before the Honorable Single Bench.
According to how many persons? 500.
566 is the number of read petitioners.
This is the number subject to correction of my learned senior friend. Probably only 5 read petitioners in their knowledge. There are several read petitions pending.
End of the day, what if you 100 petition application for the cut off cases.
And only one thing, when the matter went before the Honorable, I don't know what is the number of applications filed after the remand to this Honorable Court. There may be a cut-off date fixed for the purpose, beyond which persons may not be considered. Please come to the order passed on by this Honorable Division Bench at the interim stage from which the appeal was carried up before the Honorable Supreme Court. This is the order dated 19th of May 2023. But the court was pleased to record that that's page 693, Lordships may straightway come to 693 in the 3rd volume. The spiral binder. 93.
Yes.
This is the interim order from which the matter went up to the Honorable Supreme Court. That
we will not go, we have, point out now what you are wanting.
No, the court records that a cause of action accrued only on discovery of fresh materials placed before the board by the board on 28th November 2022. I wanted to show this to your lordships. As a consequence thereof, the Honorable Singh,
Final order.
but not as a matter of fact,
All right.
this remains.
Observation is there. Yes.
Now, my lord, on the aspect of opportunity of cross-examination not being afforded to the writ petitioners, I need not trouble your lordship because the statute is very clear. Section 165 of the Evidence Act does not normally require a cross-examination to be permitted. Normally, yes. And they were offered, in fact, persons who were deposed were offered to be cross-examined. Board refused. Not persons who were the interviewers or not the persons responsible to take the test, they themselves said that we had not taken the test. And this the court wanted to elicit, which the court is entitled to do.
Either you set aside the entire thing, let 33,000 go.
Recast.
Let 33, that's the selection. The process has to be set aside pertaining to the non-trade. So this 33,000 will lose their term. And your alternative submission is, all right, my lord, don't go to that extent. Give me a job, I will be satisfied.
No, I put it in this way.
So this is what.
No, I put it in this way. 32,000 may not have to lose their jobs. If your lordships are today persuaded to hold that 5 marks are required to be allotted to each of the candidates, irrespective of their, because of their participation in the process, because of a process being wrong, faulty, to the extent of 5 marks, allot 5 marks to everybody. Now consider their candidature in the light of the merit panel to be prepared. Recast the panel. Somebody may stay in, somebody may have to go out. Please visualize the competing.
Panel is altogether not there.
So that's why it has to be recast. It has to be done.
How? What will be the solution? Suppose 5 marks is given to the aptitude to everybody, all non-trade. Then how it will be determined then there will be again a spat of litigation.
Not there has been a breakup marks given by the board pursuant to orders passed by this honorable court. Not from which I can straightway demonstrate that I have got more than at least 659 candidates. Petitioner number 1 is more than, has attained marks more than at least 659 candidates. Even considering the marks in the aptitude test. Where will this presumption lead to? Now, your lordships are.
2016 election process.
No, your lordships are.
State of records is this. How they will recast?
Not appointed in 2017, 18, 19. 18, 19.
So there is a plausible solution.
Right. I'm trying to give this.
5 marks is given to everybody. Now, upon this recast, how many of them will remain and how many will go? You can tell.
Not same. Not without 5 marks. Not there are 2 options. Not one, they take these 5 marks, or they take away these 5 marks. The numbers are before this court. Now the board knows who has got what marks. I can demonstrate before this court straightway that there are at least 659 candidates beneath me working in a district. Number that trained candidates remain untouched because 15 marks is allotted for the trained candidates. So 5 marks for aptitude test does not concern them at all. Even if they get 0, they are always 15 marks ahead of the untrained candidates. Aptitude test does not concern the trained candidates at all.
Why?
They are always 15 marks ahead.
That is separate, but this aptitude test provision was there for those trained candidates.
Now I'm not. The trained candidates have to be given a preference in terms of the existing rules.
Persons, participants were ranging from age of 18 years to 40 years.
40 years.
A person of 18 years have appeared in their HS examination, say in the late 2020s, 18 years. And a person who is 40 years who must have obtained HS about 20 years ago. If you make that argument, how can you weigh this? A person, suppose I passed out in 1982 in, say, our board examination, and you are passing out in 2002.
Parameters change.
Parameters changes.
Right. But the
an examiner will assess. Suppose I got in our days 90% and above was later mark. So suppose I have obtained later marks in 1982 and a person 18 years older to me must have obtained that HS candidate with much less marks.
Must have.
Much less
But
marks.
today we are considering a process where everybody has participated on the same platform.
What can you are saying you are giving a solution to the court.
Right.
You are saying take away 5 marks or you deduct 5, take marks or give 5 marks.
In the same process. In the same process, not a fresh or subsequent process.
Yes, all right. Anything else?
But otherwise the course left is to recast the panel. But I just demonstrate for your lordship's kind consideration 2 situations. Please take note compilation to the issue. But the breakup of marks which the board produced.
We have taken that much persons, much beneath your marking has got a point.
And apart from reserved, unreserved category, the reserved category candidates being shifted to unreserved category in terms of the own merit rule, but everything has not been followed. Nothing has been followed.
Page
The convenience, that's part of the rules.
You are taking us to the rules.
Yes,
Tell
yes.
us which rule.
The 2016 rules.
Yes, which rule?
Rule 8.
Yes, rule 8.
But the system of marking does not have a reference to percentage of marks obtained in an examination. Madhyamik pass under the West Bengal board is 5 marks. It's pass. Higher secondary pass is 10 marks. Training as specified by NCT is 15 marks. Teacher eligibility test is 5 marks. Extracurricular activities is 5. Viva voce is 5. Aptitude is 5. So it does not have a reference to percentage of marks obtained at each stage or in each examination. Therefore, the problem which was probably haunting my lords will not have an application in the fact situation of this case. Now, please come to note 1. The percentage of marks obtained by the candidate in the Madhyamik or its equivalent, excluding additional marks, if any, shall be reduced proportionally to marks obtained out of 5. The percentage of marks obtained by the candidate in the HS, if any, shall be reduced proportionately to marks obtained out of 10. So 100 is 10, 80 is proportionately reduced. It's like that.
Here the problem comes.
But they have all participated.
You are right. The percentage marking is not there under. But under the notes, this deduction exists.
No.
And this is bound to affect.
18 to 40 might have applied, but not they have all participated in a single selection process on the same platform.
And what is your answer to this common panel which was said that the trains would also be coming?
No, trend is not an issue. We have not challenged the participation of the train, not their selection.
What you are suggesting that give or take away or give 5 marks.
No, I
altered the panel position of the.
It will not alter for the train. Please come to page 5, that rule 8 once again.
Yes.
Training as specified by NCT carries 15 marks. So whoever is trained, he straightway gets 15 marks. And even if he gets 0 in the aptitude test, that does not impact his position, even vis-a-vis an unqualified or an untrained candidate. in terms of 8.8, sub-rule 8 of rule 8. Please see sub-rule 7 first. While preparing the panels mentioned in sub-rule 5 and sub-rule 6 above, the selection committee shall at first divide all the candidates who will be found eligible after the interview into two categories, trained and untrained, and thereafter two separate sets of panels for each category. Shall be prepared, one for the trained and the other for the untrained. So exhaust the channel of trained first, and if there are vacancies remaining, then try to appoint persons from the untrained panel. That's the requirement of the rules.
Yes.
Now, your lordships are considering as to the plight of the persons who have already been working. Not what about us who have been wrongfully deprived? And that's the question which I am flagging up for as an issue before your lordship. Now, this is really a positive equity to be maintained by this honorable court now. Not only for the purpose of I tried to.
You have already suffered
Do I,
for 9 years.
so not I get stand in front of a firing squad and get myself annihilated.
33,000 is not at par with you. They have maintained family. 33,000.
We have been deprived wrongfully. But if
the equilibrium apply, Mr. Wood?
not one has been unjustly benefited, I have been wrongfully denied.
That can be that question comes as regards compensation of this person.
No.
Persons who have already been appointed, today if you throw them out of employment and say that you now participate in the exam. We are just discussing. It's not that we are trying to.
No, I am
nowadays this live streaming says tomorrow evening we will find that the judge has said this. This is the problem, because conversation between an advocate and a judge may not be appreciated by the social media.
I'm not. What I was submitting is this. Today, the marks of every candidate has, by reason of the interdiction of this honorable court, surfaced. If it requires a recasting of the panel or preparation of a final panel, not recasting, it's preparation of panel for the first time. In view of the unequivocal expression of thoughts not by the expression of the board in 2022 November, pursuant to the order of this honorable court, that it is faulty. That some is a beneficiary of a faulty exercise, if I may put it in this way. Not to speak of corruption, I have demonstrated in my writ petition that one who has been marked as identified as Y in the TET examination, he has been appointed. No name.
Oh, no, that has been explained.
That has been explained. I can't fathom. I need more details. Now, I'm not. That is one aspect of the matter. If the marks having been now surfaced, this has to be now reconsidered by the board. If the other vacancies can't be filled up by the persons who have approached the court in time.
throw them.
Not through them. Some may remain, some may not remain.
But then suppose we are satisfied with the argument which we have been advanced. Today we set aside, this is a human issue in work. Now today we set aside the entire given money. Can this issue be determined?
No, I'm not.
Not determined, then the persons who are not, what should I say, they are honest. They have not done anything for the wrongdoings of their colleagues. Today they are faced with such a situation. But how will you link that this person is linked with that disaster, this process which has been done?
My lord,
This is not linked.
today there are available marks of everybody. District-wise, category-wise, medium-wise marks, the board has still not disclosed, but the individual marks are available. They are required, all that the court may direct the board to do is perform their statute.
Before I open this case, it reminds me, Milord, Sir Ashutosh's one statement that the law is neither a trade. I'm representing the read petitioners and the CAN applicants who are also the read petitioners reach their file. Therefore, all these CAN should be.
Matters in which is the particular.
Milord, in a list, Milord, I know. Therefore, Milord, it's very important, Milord. It's just, Milord, I was going through and learned a lesson. The law is neither a trade nor a solemn jugglery. This is a living science. And in the truest terms of the words, the duty of science, as Saraswati said and subsequent judgment, is to find out the truth, go to the root. And while the Honorable Constitutional Court is considering that the basic duty and responsibility to all of us is to ensure that the constitutional morality and principle is upheld, bereft of any other consideration. Number some of the সব ক্যানগুলো লাইছে আমরা
And can
70.
Can 44 and can 70. Those cans have not been allowed. Only can
all these cans needs to be allowed, otherwise it will complicate and multiply the proceedings. The read
has been a date was said that by this time those who come they will be given entry. That was pointed out in one.
It's not correct. It's not correct. All these cans before your lordship are the cans who are writ petitions are pending before this court on the same issue. Therefore, when the
How can they be already allowed?
Our
Can
objection
two
is noted.
Can two is already
can which were allowed and which requestive allowed.
I give a list.
Can 2, can 7, I shall hand over the list. Can 22, can 48, can 49, can 53.
Give us that list.
I shall give the list.
এই দুটো লিস্ট দিয়ে দিচ্ছি
একটু টাইপ করে দিতে পারছো না?
টাইপ আমার তো
হ্যাঁ,
টাইপ করা আছে।
সবগুলো একসঙ্গে টাইপ করে দাও। I just hand over the list. These are allowed, তাই তো?
না না এগুলো দুটো অ্যালাউড ক্যান 2 আর ক্যান 3 অ্যালাউড
এটা allowed লিখছে এখানেও?
হ্যাঁ can two allowed.
শুধু 2 আর 3 অ্যালাউড only can 2 and can 3 allowed.
Number of applicant.
Allowed কোথায়
Which
লিখেছে?
allowed by which order that is also mentioned.
Only can 2 allowed.
Can two and can 3.
Can 2 and can
3 is allowed.
7.
873.
Yes,
not allowed, subject to my lord, not allowed, subject to my lord decision.
allowed.
Anyway, my lord,
Maintainability, not allowed.
my lord, these technicalities would not stand in the way, my lord, for considering, my lord, justice. Kishe supplementary. Now, my lord, we have also used, my lord, and supplementary affidavit in Can 2 to show these are all.
No, not dutiful. Already, it is already.
All the documents which are referred to the documents of the primary board, no new document, no secret document.
Hold on.
Have access to those documents.
Yes, I will give.
They are required to file opposition to the CAN. They will be taking a stand.
Already disposed of. Can 2 is already disposed of. Can 2 is already.
Now, my lord, reading no doubt.
Can 6 has been allowed.
Can 2 allowed.
Can 2 and Can 3 does not feature.
No. Number of.
দেখাতেই তো ভুল
Can 2 has been allowed.
Can 2, Can 3. আমার নোটটা কোথায়?
Can 2 and Can 3 perhaps have been allowed.
Yes, well, let me rely on Can 2 and Can 3. That will suffice. Lord,
Can 2 and Can 3, which has been allowed.
Can 2, Can 3 also Lord, discloses that there has been Lord, gross nepotism, rank jumping, and manipulation. These all Lord, hits the.
We will sort it out.
This all Lord, goes to the basic question of Lord, the violation of Article 16. That if anything is done in violation of Article 16, well, there are series of judgments, even a person will not.
Mr. What is the first address us on this point? On the basis of this pleading, how far a person can go? On the basis of the pleading,
Lord, on the basis of the, that's why I started Lord, with that Lord, the quotation of sir.
must uphold the constitutional.
Yes, now Lord, on the basis of the pleading, if your lordship gets one indication, then my lord will definitely to try search out the truth, and that truth is from Lord the statutory bodies. Lord, we are not fighting Lord one individual against another. These are all we are challenging Lord, the actions of the statutory bodies, who are Lord, trustees of the Constitution, who are Lord, there to uphold the principles of Constitution which they have failed. Now, Lord, I just take your lordship Lord, few paragraphs of the pleading. দেখো দাও মুখ না পেপার বুক ওয়ানটা কোথায়?
পেপার বুক ওয়ান
এগুলো তোমাদের তৈরি থাকো না তোমরা
কি দেখতে আমার পেপার
কি তুমি আমাকে দাও প্লিডিং গুলো ক্যানের
ক্যান 2 দেখাবে
চারটা হোক দাও দেখেছো তোমরা তৈরি নাও তোমরা কেউ তৈরি থাকো না খালি বক বক কর
ক্যান 2টা দাও স্যারকে স্যারের কপি দেওয়া নেই ক্যান 2
আমার তো ব্রিফ গুলো কোথায়
আপনি 220 থেকে সব করতে থাকুন এক্সটেনশন
This is affidavit of money. আমি তোমরা না ছাড়ো kindly come to me that Can 2
না পেপার বুক 1
আমি তোমায় Can 2 দিতে বলেছি
ক্যান 2 পড়ছে ক্যান 2
খালি বক্তৃতা করবে কাজের সময় থাকে না The Can 2 Miller paragraph 21 here we must say that there has been violation of reservation policy and also Miller rank jumping. I'm just referring, I'm not reading that and wasting my lord's time. I'm at page 153, 353, 353, instances of corruption.
Page 153.
Page 153
Our
of,
application
of
does not
Can 2.
can do.
No, that is
Bhattacharya is referring to Can 2. Materials are being adduced.
Sep-
Can 2 has been allowed subject to maintainability. So, Malad, if Mr. Bhattacharya places reliance or places in this application, we should have a right to file an opposition because these are new materials.
What they are appeal.
These are absolutely new materials. These were not
No,
before
their
the
appeal
trial.
no, they are not appeal.
But Mr.
What
Bhattacharya
appeal?
is arguing from Can 2.
Of
Can 2 is a new
873.
material, my lord.
no. Can 2 was allowed.
Not served upon us.
Why you will support? They are
paid.
আলাদা appeal. ওদের আলাদা appeal.
তুমি তো এই appeal পার্টি নও ওই appeal তুমি নেই
It is an application taken out in the appeals prepared by the board.
Yes.
But all the appeals are being heard together. Well, we have our independent appeals. So these can
You that you have in depth argued your matter. So now let us not go into factual issues. Let us find out from him if you are still if you want to address us on any particular point. Please help us also that you can cut it.
Wait, my lord, I'm not troubling my lord with Can 2, Can 1. Let us come to the my lord, paper book itself. Paper book.
Yes.
Now, my lord, this is the prepared by the board.
Yes.
I just my lord, take your lordship, my lord, first to the recruitment rules straight away. It's not waste of time, my lord, on factual aspect.
Yes.
Will kindly notice the definition of council. I'm just referring to. If you want to file affidavit, you file it. Why did you not file so long?
There is no direction for that.
Well, is it direction necessary for filing affidavit?
Necessary. You are bringing certain materials which are not before the court.
He is arguing on the paper book.
Not Mala. Now he is saying that he is arguing on.
Mr. Shamim is the troublemaker. He's a troublemaker.
Take appropriate steps. Yes, sir.
Now, my lord, kindly
Mr. Bhattacharya,
Page 114 of the paper book.
Yes.
This is the selection committee. Board shall constitute selection committee within the jurisdiction of the council with the following members. Well, this is the requirement of the statute. And the selection committee shall function for 2 years. Now, procedure of selection. Now, I do not subscribe to this view that since they had TET 15, therefore the aptitude test is not necessary. The aptitude test is very much necessary for everybody to assess whether he is capable of teaching. Mere securing 100 marks in the examination does not entail somebody to be a competent teacher. That's why this aptitude test and viva voce was introduced. Now, this test being very important, my lord, it requires that it should have a compulsory compliance. Otherwise, the rule makers would have simply relied upon the total marks obtained in the examinations.
Yes.
Now, kindly turn to me, Lord, the sub-rule 5 of Rule 8. The selection committee shall prepare separate council-wise panel as per procedure below. Firstly, the selection committee shall segregate all eligible candidates applying for earmark vacancies mentioned in Note 7 to Rule 6 from other successful candidates. First, not shortlisting, if I may use that expression. Secondly, the selection committee shall prepare the following panels for the successful candidates who have applied for non-earmarked. 2 separate panels, one for earmarked, other for non-earmarked. These are the important, kindly keep it in mind. Then a panel of all selected candidates in a district, namely unreserved category, comprising of the names of the candidates belonging to general category and reserved candidates of scheduled caste category, scheduled tribe category, OBC category, serially according to descending order of merit as per existing vacancies medium wise. But there has been a definite assertion, my lord, that reservation policy was not followed. That is in the can. This is necessary because of the rules. Then a panel of selected reserved category candidates in a council, namely scheduled caste, scheduled tribes, OBC, so and so, respective category as per statutory reservation from amongst the remaining candidates of such categories, serially according to descending order of merit. Then exempted category, I am not troubling my lord with that. Therefore, the preparation of panel according to merit was one's mandatory duty of the selection committee. And the allegation is, which is not controverted, that no such panel was ever disclosed. Now then, my lord will kindly come to page 126. This is of 8th of September 2016. And the advertisement was published on 26th of September 2016. And this date is 8th September 2016. Therefore, before the advertisement was published for recruitment, they have the communication with so-called officer in charge in confidential section. Is it the statutory body under the rules or under the act? The officer in charge of confidential section, the reference is test of 2014. I am directed to inform you that the points mentioned below be followed while result would be processed. Therefore, the Secretary of the Primary Education is transferring his statutory duty to an outside agency. What is to be processed? Qualifying marks would be minimum 60%. In case of a candidate with same roll numbers, result will be kept withheld, and they will be requested to meet the secretary with all documents within 10 days of the publication of the result. In all other queries, actions to be taken followed in TET 2012. What does it indicate? It indicates that the secretary, when there is a tally, would have personal interactions.
That is pertaining to TET 2014.
Right. So the TET 24 is one of the eligibility.
TET 2014
Is one of the qualifications.
you are successful in that.
Lord, I am showing Lord the process. Lord, this is a systematic fraud. That systematic fraud was revealed in another proceedings, and which was appealed up to Supreme Court. I am indicating this to Lord to show how the system played the role of a fraudster. Then kindly come to me, Lord, next page. This is of 6th February 2014. Now, this company, I do not know what is the qualification of this company. He writes to the President of West Bengal Board of Primary Education, the quotation for printing and delivery of OMR answer sheets and processing of results for candidates appearing at teacher review tests conducted by West Bengal Board of Primary Education. My lord, again see this is relating to TET, no doubt, but this is the system followed. Here, my lord, that private agency is writing to President. This is in reference to the discussions we had with you in regard to computerized examination. What is the transparent? Gives quotation. But this is a private negotiation, suffering from lack of transparency. And what are the below job description at page 128? Post-examination works. I'm just putting across the relevant portions. Scanning of filled up Weimar answer sheet received from the board by Weimar scanning machine and preparation of database files on the scanned data. Then 3, removal of discrepancies relating to roll number and answer sheet number by checking the respective documents physically. Then 5, evaluation of answer sheets data of candidate as per answer keys of different question booklets set as submitted by the board. Then processing of final results as per parameter given by the council and creation of qualified candidates file. This is done by an external agency. Then my lord will come to page 130. This is of 14th September 2016. Again, I refer lordship below, the date of advertisement is 26 September. The board is writing to the confidential processor who had written the earlier letter, the rates for confidential works as detailed below. I am directed to state that the results of TET 2014 have been announced on 14 September 16. Now the following works are to be done stage by stage. What are those works? Arrangements are to be made for online application for 1,25,000 TET qualified candidates for collection of fees thereof. Then After receiving the online applications, arrangements are to be made for printing of district-wise list for scrutiny verification. Arrangements are to be made to take up scrutiny verification. Then you are requested to submit the rates for above stated works in this board immediately, separately for each stage. That this rate is sought for from the so-called confidential process for recruitment process. After this is post-state. But what was the method of selecting this authority? Then the next page, 131. So-called confidential processor rights. This is in reference to the memo so and the recent discussions that we had with you on the above subject matter. We are pleased to enclose our proposal for the above assignment. We are confident that you will find our quotation very competitive. With whom? We now look forward to receive your positive response in the said matter. What for? Kindly see the subject. Proposal for online application processing for interview and collection of fees relating to qualified candidates, State 2014. That corruption breeds there. Then my lord will kindly turn to page 133. Page 133, my lord, down below, paragraph 5. Post-interview final panel list. Collection of candidates' data from qualified candidates list of interview test. Candidates' details obtained for extracurricular activities. Training details, viva voce marks, aptitude test, and experience marks for para-teacher. Final calculation of overall marks for each candidate. Preparation of panels for candidates merit lead as per rules. Now then, kindly turn to page 134. I believe this is RTI reply. This is based on RTI reply. Serial number 2.
Yes.
প্রাথমিক শিক্ষা পর্ষদ 2016 সালে 20টি জেলাভিত্তিক 42,949 পদে নিয়োগের মেধা তালিকা তৈরি ও বরাত পায় এই এস বাসুরায়ন কোম্পানি। এখন প্রশ্ন, জেলাভিত্তিক, মিডিয়াম ভিত্তিক, ক্যাটাগরি ভিত্তিক মেধা তালিকা আদৌ সঠিকভাবে তৈরি হয়েছিল কি? উদাহরণস্বরূপ ডিপিএসসি হুগলির উদাহরণ দেখানো হলো, যেখানে 264 ধরনের বিষয় ছোট ছোট মেধা তালিকা জুড়ে জেলাভিত্তিক মূল মেধা তালিকা তৈরি হবার কথা। This is a part of their paper book. And not the DPSC Hooghly instance, which is again I say this is the paper book prepared by the board, not by me. And then will kindly turn to page 149. Again, this is of the West Bengal Primary Board.
Yes.
This is on 3rd of March 2023. Information sought was a TET marks and photocopy of AMR sheet of primary TET 2014. TET roll number such and such. The reply is important. Information provided.
Where you are reading?
Page 149. এই ডকুমেন্টটা পড়া যাচ্ছে না, ভালো করে টাইপ করাতে পারো না তো ওদের পেপার বুক হলে তুমি যখন দিচ্ছ করতে পারো না, বাস এটা পড়া যাচ্ছে না। বলে রাইট হ্যান্ড সাইড ইনফরমেশন প্রোভাইডেড pursuant to the converging and unanimous resolution of the former ad hoc committee held on 3rd April 2017 under the chairmanship of the former president of WBPP. The original OMR sheet relating to TET 2014 have been recycled after completion of storage of the database pertaining to the marks in digital form. Photocopy of individual OMR sheet cannot be obtained from RTI application. However, any interested applicant seeking information of the details can obtain on payment of prescribed fees of 500 only by a demand draft drawn in Nationalized Bank in favor of the West Bengal Board of Primary Education. It indicates that OMR sheets are there. They can only provide if you pay 500 rupees.
This is pertaining to TET 20.
TET 2014. Now, in examples, some of the examples are given at page 153. Showing these facts are already before Your Lordship, I'm just giving the references. The persons who secured much below marks were given appointment. The entire bunch is here. আমি ওর অ্যাফিডেভিটটা
How the marks obtained beneath your score. Where from do we get it?
Look, we given the chart.
This is a chart of the candidates who were appointed breakup.
Yes. Now, my lord, the vis-a-vis, my lord, the persons, my lord, who had secured marks also mentioned.
Yes,
Their details are all, my lord, given in the can which they register us. But these are the, my lord, source wherefrom Your Lordship get it, and Your Lordship would, deepest of respect, my lord, inquire from the Primary Education Board to satisfy whether these allegations having one single instance really confronts with the records or not. My lord, Constitutional Court, my lord, should not really remain confined narrowly that whether you have given detailed pleadings. My lord, I have not the detailed material on with me. I am mere a candidate. When I find something wrong, I point out. Then, my lord, the responsibility is onus on the authority. I again say, my lord, they are the trustee of the people to ensure that the recruitment process is done properly. They have to satisfy how it is done. এই affidavit দাও, পুরো affidavit দাও। এই কার affidavit?
দুটো কপি দাও।
Now, this is the affidavit. It was filed by my lord S. Basu and Company. This is a, my lord, court of records, and this is a part of, my lord, record in a proceeding.
Obviously. This was not there.
Let kindly come to 221.
Page 21.
Let this is a truncated affidavit quoted.
20, part of spiral binding not supported by affidavit.
Very well.
It was before the court below.
And my lord, these affidavits were filed by the authority in the High Court. High Court is the court of records.
Page 221 is an extract of the
Yes.
filed by the
My lord, this is the extract of the affidavit, my lord, annexed by. না না এখানে 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 এলো কি করে?
স্যার আমি বলি কি, এই যে এফিডেভিটের পাতাটা, এটা নিচের কোর্টে তরুণ জ্যোতিরা ফাইল করেছিল, এটা স্পাইরাল বাইন্ডিং।
Yes, now I'm told, my lord, this is a part of the spiral binding which was accepted before this. Now, therefore, my lord, let us read the entire affidavit. The entire affidavit I have my lord, given lordship for assistance.
That has not been given, Mr.
My lord?
That was not there before the single judge.
Yes.
Single judge took
That was there. This, my lord, this affidavit is a part of, my lord, the paper book. I want to point out the affidavit which has been quoted here. It is partly quoted. I want to place the entire affidavit.
You place it, the allegation which you are making, that is evident from paragraph 26, which have been page 21.
Now, my lord, this page 221, lord, is a part of an affidavit.
Yes, yes. Of course it has to. Yes.
No, I fail to understand, my lord. I state that the West Bengal Board of Education asked S. Bharat Chaudhary. This is paragraph 26 of an affidavit. My lord, they did not annex the entire total affidavit. I want to place the total affidavit to disclose what has happened. Why are they scared of placing an affidavit which is part of the record of this court?
And this affidavit was before the learned single judge?
Yes.
থ্রি স্পাইরাল ইয়েস
হ্যাঁ
থ্রি স্পাইরাল ছিল সেটার যার নাহলে বোর্ডের লোকে
Mr. Mojumdar, finish whatever objection you have, you raise.
No, but
We won't.
but I take the extreme point that this affidavit was not placed before the single judge. But this is an affidavit by a statutory body filed in this High Court. So can I not? Refer this affidavit, my lord, being the court of record. High Court can see this record.
Yes, yes.
Yes. That's why I am placing this affidavit.
স্যার এই যে এটা আপনার মার্ক করাটা
মার্ক করে কোথায়
স্যারের মার্ক করাটা কোথায় কালকে এটা মার্ক করলো
have a copy of this
হ্যাঁ সেটা বলো
ওটা দিল রাকেশ মন্ডলের এফিডেভিট
তো ডিফারেন্ট ম্যাটারতে কি হয়েছে
আমরা একটা অ্যাফিডেভিটটা প্লেস করব
already given. Similar one thing I make it lawsuit. This was not before the learned single judge.
Mr. Sarkar, you have annexed an extract of the evidence and you are saying that I.
We have not annexed it.
Yes. It's 26. It's 20.
Spiral binding, not affidavit.
Binding contains the extract of the evidence.
Spiral binding not supported by affidavit.
Oh,
separate issue that you have already argued, we will take care of it. But this document is when it is there, and if some document is trying to be pointed out to us, we are bound to see that. We should be given copy of that. We will consider that.
আমার অ্যাপিলেন্ট আমি
Sir, it's of the board's evidence.
yes
No.
we have given copy to the board we have prefer an appellate board
No.
Mr. Sannal, board has filed a spiral.
No. Petitioner. And most of the documents prepared by them not even belong to the board.
No, the one which you have annexed to 873.
That's spiral binding.
Yes.
So of the petitioners without supporting any affidavit, but most of the documents are not of the board documents. We didn't file any affidavit with that.
Showing your affidavit, board will answer that.
Well, I kindly have a look
You
at.
are for one of the person, so it is a.
I'm for the board.
No, you appeared for.
Well, one I also out appear for the board before your lordship, also for para teachers in one appeal.
এবার কি করে
কেন হয় না?
ওদিকে একদিকে 100
There is
board
no
and
one
another
for-
100.
No, I am not representing any common to come back.
You argued on the basis on the paragraph.
Well, I argued, I passed all of them because all of my seniors, that's why I didn't get the chance.
শোনা
No, I'm not repeating that. If I will keep my-
Understand each paper which contains pages 123 to 237 spiral submitted by the petitioner without evidence. You have said that. Now we are whatever is there, it is there. He wants to point out something from the affidavit, a part of which was annexed to that spiral. Let us see.
Well, that's affidavit not in connection with this matter.
doesn't matter.
That is,
Well,
let us, Mr. Thandal, let us.
Look, this is an affidavit filed in
Yes,
কপি দিয়েছি সবাইকে দেবো না স্যার শুধু বোর্ডকে দেবো
yes.
দেখালে কোনো প্রবলেম নেই
Now, but
Only copy will be given to.
this was an affidavit by, well, I know why they are not really getting scared. This is affidavit. Yes, Basu Rai Chaudhary.
Yes.
I state that Mrs. Basu Rai Company is a partnership firm. Well, there are 4 partners. I do not trouble that. Kindly come to paragraph 5. I state that as directed by the Honorable Justice Obijit Gangabata on 20th January 2023, I am hereby affirming this affidavit in opposition. I state that in or about month of February 2014, the President of the West Bengal Board asked Mr. Gautam Mukherjee, the partner of Basu Rai Chaudhary, to give quotation. Now, this goes to the root. That's why they are scared of this. The partner of Basu Rai Chaudhary.
This goes to the root pertaining to date 2014.
No,
which you participated and you were
no,
successful.
I am not on that.
No, your argument is that even if I am successful, but after getting the documents, I find that in the TET examination also this corruption originated. It was given to a private
Right.
person.
My point is that. And that.
We are hearing only on that now. We
No,
have already told you that TET 2014
over.
examination is over. You were successful. There is no prayer in the writ petition that turned down the TET 2014.
I am not on that. But
You are arguing, you are saying if there is a trustee.
I say systematic fraud, how generated. This is more important than
This is like Mr. Vadajaji, after new materials come, something. Litigation has to end at a particular stage. This argument which you are advancing, that see from the records, that where from the, because you are arguing systematic fraud for striking down the entire in support of such contention.
Yes, right, so. Right, so. My lord, absolutely right.
Yes, anything else you want to show us?
Yes, this is important. Let me place it. I state that in or about the month of February 2014, President of the Board asked Mr. Gautam Mukherjee, the partner of Basu Rai Chaudhary, to give a quotation for working of printing and delivery of OMR sheet processing of 10/2014. This is the source where this Basu Rai Chaudhary comes. Then kindly come to the paragraph 8.
Yes.
West Bengal Primary Board accepted the quotation. Well, this is purely, Milord, private arrangement between one company's agent with the president of the board for selection of the agency to conduct examination, which started at TET. It continued in selection process also.
Now this date 2014 conduct, the manner it was conducted, is there any rule to that effect?
No, there is no specific rule under 814. But so far the selection is concerned, there is. And the
state conduct the state examination, there was
no rule. But in the selection, there is a rule where
agency can be brought.
Yes, and the specialized agency was chosen in what manner, that is more fundamental.
Yes, that you show us.
That I am showing. Therefore, here admittedly,
we have understood what you have.
Yes. Therefore, this is only Basu Rai Chaudhary partner. He was approached by the president, give your quotation, I accept your quotation. That is more important, because I shall demonstrate how these points went up to the Supreme Court also. Then I state that as per the direction of the West Bengal Primary Education Basu Rai Company complied the order mentioned in the letter. I say that then paragraph 11. I say that the West Bengal Primary Education some guidelines to prepare the result as per their guidelines. Then paragraph 12, I state that this is very important. West Bengal Board of Primary Education further intimated Basu Rai Chaudhary that if the Honorable High Court would direct to publish the result on 14 September 2016, the same would be published on that day. I state that as per the instruction of the Board of Primary Education, Mrs. Basu Rai Company did the job. Therefore, the Basu Rai Company, Milord, published the result of 2016, 14 September 2016.
Of date 20.
No,
824 is not, yes. Then
Yes.
the paragraph 15. I state that the West Bengal Primary Education on 14 September 16 by letter asked us to develop an online application portal for the qualified candidates for submission of details and collection of fees and for scrutiny verification for the qualified candidates for recruitment. I state that as per instruction direction given by the West Bengal Primary Education on so and so, Basurai gave a proposal to the Board of Primary Education for doing such work. I state that the West Bengal Primary Education notified a link would be created for the qualified candidates to fill up their details by and pay the required fees for the same. Said notification was published for vacancy of 41,559. Herefrom, the selection process of recruitment starts. I state that the West Bengal Board of Primary Education directed Basurai to provide a scrutiny verification as per the district-wise. Same was submitted to the West Bengal Board along with the attendance sheet. The scrutiny verification has provisions for writing viva voce marks, aptitude marks, and so and so. Then will I skip over the other paragraphs? Kindly come to paragraph 23. I say that as per the requirement of the West Bengal Primary Board, Basurai Company updated the same in data of the candidates and sent to the board a final error list containing errors marked by the system for checking and get it verified. Then again, board updated the final list and sent it to them. Then paragraph 26, which was truncatedly annexed in the paper book, that's important. That's why I placed the entire paragraph to show the source. I state that the West Bengal Primary Board asked Basurai Company to prepare the initial empanelment list for trained and untrained candidates. That the said list was prepared by the company and delivered to the West Bengal Primary Education Board, indicated below. The figures are there, I'm not troubling. These details are there.
It is page 7, 8, 9
Right.
were annexed.
Yes.
In the spiral binding by the petition.
By the petition.
Omitting the portion pertaining to TET.
Yes.
Because they were successful.
But the petitioner did not appreciate that the source, if it is tainted, it goes to the root. Then we'll kindly come to paragraph 32. Is only surviving partner. And I'm told Namla, he is no more in the world. Mr. Gautam Mukherjee. Therefore, the Basurai, all the partners are no more now available.
This person is there, Maji.
So Kartik Maji, I'm not sure. I'm told Milot, he's in custody. Right? I'm not sure. Kaushik Maji. The Kaushik Maji was in custody. He.
Gautam Mukherjee, Barindranath Das, and Kaushik Maji. Ashok Maji, Gautam Mukherjee, Barindranath Das, all have.
All died. Kaushik Maji is alive. He's in custody.
Oh, he's in custody.
Oh, I mean, now recently granted bail. But these I simply repeat, these I place to show that the fixation of everything initiated with a corrupt mind by selecting an individual. I would appreciate it. that they have floated a tender that we want the experts who are in the field, please apply. That the similar situation was in case of SSC, where the 3 persons were called, 2 were rejected on the same ground, they are the government agencies, and 3rd person was appointed, handing over the appointment letter on the very same day. The court said this is the initiation of systematic fraud.
24 of the division.
That would you should get the reference to division bench judgment at para 324. Division bench judgment also দাও আছে আছে বোধহয়
কম্পাইলেশন গুলো দিই
মানে SSC judgment
ও
SSC
no
I want to show that Lord, that was the foundation. But
যত জাজমেন্ট রেফার
আরে
ওরা অনেক
one NISA. One NISA was the selection process of NISA was found to be, my lord, absolutely corrupt. I am referring to paragraph 324 of the division bench judgment. My lord, I have handed over. Read it, Ashok.
there we shall take note.
I'm the read out. May I read out that part?
Paragraph
324.
page number 685 compilation এ আছে সেটা
But I am told that's a part of compilation, page 685.
ওটা দিয়ে দাও
জাজমেন্ট কম্পাইলেশন অল জাজমেন্ট কম্পাইলেশন মিস্টার ভট্টাচার্য
No, we have the compilation of judgments.
compilation of judgment
that it is given.
Yes.
today yes
No, no.
আরে এটার মধ্যে আছে তো
হ্যাঁ ওকে yes
কথা বলো না Lord, I am reading out very lightly. Significantly, Messrs. NISA had been appointed without an open tender. SSC had selected NISA ostensibly on the ground of it being the lowest tenderer from amongst a chosen few who were asked to participate. The parameters, qualification required to participate remains undisclosed. Despite requests being made in court to SSC, no explanation has been provided by SSC in course of the hearing as to how and why such a course of action had been undertaken in identifying the instrumentality who was to scan and evaluate the OMR sheets. Documents that had been made available on record does not suggest that competency, efficiency, and whether Mrs. NISA has the requisite expertise to undertake such exercise was not considered by SSC at all. Letter of appointment of NISA contains only 2 lines, which requires NISA to scan and evaluate the OMR sheets. No other terms and conditions of the appointments have been specified. The appointment letter has been received by the one employee of NISA from the office of the SSC. Then SSC had destroyed the original OMR sheets ostensibly by keeping the mirror image thereof in server. CBI did not, well, this is on different card. Then 326.
Tender was doubted. In that case, similarly here, no tender, no reason why you have been selected. And this is a private body.
Private body, one individual is talking to the chairman and chairman is doing.
And confidential section.
Confidential section. Now that I shall straightway take your lordship to the affidavit by the board.
Affidavit by the board.
কোথায় কোন পেজ আছে?
পেপার বুক 1
কোন পেজ বলো?
এখানে মার্ক 315 মার্ক
359 one
that is affidavit by the body that which means
Like in volume 2 of the paper book.
359
But I shall show you how the present president wanted to avoid the responsibility. At page 359. I, Dr. Gautam Pal, he is the present president, he is affirming this affidavit.
he said that I have no records not available in my office. I am newly joined. I don't know anything.
Now, every authority has an institutional memory, but they don't have individual memory. The president being satisfied that the earlier president has committed something, wanted to shirk the responsibility by making this statement.
Yes.
Now, my lord, I read, my lord, in spite that lordship recollects, still, my lord, I take the opportunity to read it. Paragraph 4. From the records available in my office, it is evident that in the 2060 recruitment process, marks were given by the selectors both in interview as also in aptitude test. Then, based on the records, I submit with utmost respect that the coherence which can be drawn thus far from such grant of marks by the selectors for the aptitude test to candidate is that such aptitude test was held. No positive assertion that yes, aptitude tests were held. He was trying to draw a logical conclusion. Since marks were given, therefore test was held. Then, in 2022, recruitment process which commenced after I assumed office, board has taken various steps. Now he is now building up the safeguard which are first of its kind. Can you understand this? Taken various steps which are first of its kind to be introduced in the recruitment process. First of its kind after the assumed charge. Therefore, there was nothing before. The interview and aptitude test of a candidate for 2022 recruitment process is being taken in one single day centrally in board's office in batches. This is introduction by him after 2022, which was not there earlier. Then kindly come to the next page. This speaks of 2022.
2020.
Now, the next affidavit is also important. He had filed another affidavit at page 363.
That is aptitude experts.
We have a list, but we have no list that who were sent. I will place that.
That is lordship has observed in the judgment.
Therefore, these are then factual aspects admitted by the board, who is not authorized under the law to conduct the examination.
List of interviewers, not the persons appointed to take the interview.
Interview board was never constituted. Interview board was never constituted.
Yes, the no interview was board was. May I place this? Is important. If you Lord, kindly permit me, Lord.
নেক্সট ডে করুন
নেক্সট ডে বলে ও 4:30 বাজে subject to your lordship's convenience, I will attend.
opposition to the claim, sir. Please,
দাঁড়াও না
sir. ক্যানটা দরকার স্যার
কি বলছে দেখো
আরে কি বলছো
সব দেখাবো
এয়ার ড্রপ করে দেবো, এয়ার ড্রপ করবো।
আর তোমরা যে ফিজিক্যাল কপি সার্ভ করো, আরে তোমরা কিন্তু আমরা পার্টি মনে করি, ইউ আর নট ইভেন নেসেসারি পার্ট। বোর্ড ইজ দি অথরিটি, বোর্ড ডিসাইড করবে।
Keeping on 18th that
no, not 18th. 18th Lord, the Supreme Court is fixed. But 20th?
20th শনি না না হ্যাঁ 20th শনিবার।
তাহলে পরের সোমবার। Hopefully.
Then we keep it on 17th at 2 p.m.
No, 17th.
Wednesday.
But I shall try, but by chance, if it is not concluded, then I have to leave for 18. But since I have to be there on 18th Supreme Court, there's another service matter.
He will be there on your part. Don't worry. He will be there on your part. Then I have nothing to do. Then I can leave. 17th, it is not possible for you.
But it is possible to the extent, but if it is not finished, then it have to again will not spill over.
You have to leave early. Then you tell us which date you want.
That starts, my lord.
Habeas corpus matter, we have delivered.
But except 17, any date will not suits my lord's diary, I would accept.
15 তারিখ কোড হবে 23 তারিখে কোড
10 সাহেবের কনভিন্স দেখতে হবে তো
16 তারিখ করবে
15
কোড হবে
ও বিকাশ দা প্রথম যখন কোর্টে জয়েন করি তখন মহালয়া থেকে ছুটি পড়ে যেত হয় কি
action. The cans which has been allowed by the lordship,
Yes.
I have to rely on them. They will again take the plea. Let them file the affidavit.
Mr. Bhattacharya, we will not add to the records. You have placed affidavit exchange. It will be a very chaotic.
Can is an addition of party application. In the addition of party application, they are annexing documents which are not before the court below. This is not an
But
application.
for doing complete justice, I think your lordship will be pleased to do that.
কতজন আমার চেয়ে বেশি পেয়েছে সেটা আমি বুঝাবো কি করে?
যে ক্যানগুলোর একটা
প্রত্যেকের নম্বর বেশি
নাম্বার
Can Mr. Bhattacharya, we have there is no further documents.
কোন problem
Whatever document.
Yes, permit me to rely upon those documents. That's all.
Only the rules have been annexed here.
No,
Then can do the supplementary affidavit.
Kindly convince him. We are at a loss.
can 70
Very well, Milord. Relevant.
can 70
Relevant, Milord.
You are very senior. All of us. You have to argue on the legal points which you have.
Yes, I am arguing on legal points.
So further, because there are.
No, the problem is not here. The problem is, Milord, we are facing, Milord. The matter will go up to the Supreme Court. The parties will go and say that we are not hard. And then entire exercise would become void.
Not only hard, but
The matter cannot be disposed of, Mr. Bhattacharya.
No, it can. The scans are already on record. If they want to use an affidavit, let them.
You are filing supplementary.
these
No,
are the
forget about
supplementary
supplement.
affidavits.
Forget about supplementary.
These are the supplementary affidavits. The addition of particulars, I will take legal objection.
Yes.
Evidently, supplementary.
তাহলে আমরা বলবো কি করে আমাদের যে সমান নম্বর
My
বেশি?
brother pointed out that
I have seen it, man.
that the rules are there.
The
rules
So
are
if you think that you will have
Yes.
to say anything about this, we can hear it.
Certainly,
We
man.
can hear it. And if we hear you, then but now you want to increase on the pleadings, further documents, again reply.
No, man, that's we do not want that. Whatever before the learned single judge, we will rely on that.
Application documents. We are not allowing supplementary evidence. We are saying these two applications have been filed in this.
তাহলে তুই affidavit দে।
Anything to us. We are taking note of that, Mr. Sharma, so that at least we can we can record that we have heard all of you on the app.
স্যার 44 টা অ্যালাউ করেন ওখানে প্লিডিং নেওয়া উইথ দ্য প্লিডিং চার্ট তৈরি করে ধরিয়ে দেবো
Subject.
ভালো এই সময় দিকে যাও অনেক সময় তোমার কালো যাও কোথায় যাচ্ছে ফোন করো কোথায় যাচ্ছে ফোন করো